The Republic of Selima and the state of Kediboni were neighboring colonies of the Kingdom of Bukoda. Selima is a mountainous country known for coal and mineral mining, while Kediboni is a region of plains with a history of farming and nomadic livestock herding. Uzuri is a Kediboni enclave that was discovered to have rich silver and gold deposits during Bukoda's colonial rule, leading to the migration of Selima residents to work in the mines. During the decolonization process in 1965, Uzuri voted to join Selima despite Kediboni's claim on the region, leading to a conflict between the two countries in 1969. Selima was able to occupy the territory between the Kediboni-Selima border and Uzuri, which it refused to return. In 1974, Kediboni took advantage of a political crisis in Selima to retake the occupied territory and Uzuri, which was under military occupation until 2000. The Uzuri Liberation Front, ULF, a terrorist organization under Kediboni law, regularly attacked Kediboni armed forces and launched missile attacks on villages near the border. The Uzuri Reunification and Autonomy Party, URAP, was founded in 1999 to advocate for regional autonomy and a peaceful reunification with Selima. An agreement was reached in 2001 between URAP and Kediboni government, granting significant autonomy to Uzuri and leaving the URAP to govern it. However, the ULF rejected the agreement and continued sporadic attacks on the local government and surrounding villages, leading to the Kediboni armed forces establishing checkpoints and closing off the region to search for suspected ULF members with the help of the local police force. Ms. Lashimon Gala is the founder and CEO of Asearoma, a multinational company focused on ICT, AI, and social media. Asearoma has headquarters in Selima and is actively involved in several projects, including e-governance and smart city initiatives in Kediboni and Selima. Asearoma is collecting real-time data from public CCTV cameras, numerous apps, and social media to improve transit, traffic, health services, security, and community news. The data is collected with users' permission and stored on servers in Ife, Kediboni's capital. Jabulani, the capital of Uzuri, is one of the first cities in Kediboni where the Smart City project is being tested. In November 2021, 18-year-old Mehdi Saikut died after being chased by local police officers in Uzuri. His death sparked widespread protests and riots in Uzuri, with residents demanding justice. The government of Kediboni attempted to quell the protests by requesting access to data from social media platform Asadat and the Jabulani Smart City project to identify ULF protesters and sympathizers. With the help of Asearoma, Kediboni armed forces and police arrested many Uzuri residents in February 2022. In March 2022, the Kediboni government contacted Asearoma to inquire about the implementation of AFROPT, an artificial intelligence program, to monitor prisoners who were deemed fit to re-enter society. In April and May 2022, the Kediboni government implemented the AFROPT program in Uzuri for residents involved in spreading messages of support for the ULF, justifying ULF actions, and campaigning for reunification with Selima. These residents were confined to their homes, which were outfitted with special magnetic locks that could only be opened with a smartphone app. They could leave their house at predetermined times for necessities, with their location constantly tracked by the smartphone app and security cameras throughout Uzuri. Residents who violated the restrictions faced imprisonment. Selima went to war with Kediboni in 2022 to reunify Uzuri with Selima. The ULF gained control of much of Uzuri, including its capital, Jabulani, causing civilian casualties. Kediboni contacted Asearoma for help in distinguishing civilians from ULF fighters. Asearoma developed an AI program called Bird Target, which was adapted for the targeting systems of Kediboni's armored vehicles. The program was tested in computer simulations with generally positive results and then implemented in September 2022. During the first week of operation, units reported fewer civilian casualties and less damage and destruction of armored vehicles when operating in mountainous terrain outside Jebulani. On September 19, 2022, when Kediboni's units arrived at Old Town Plaza, the bird target software identified civilians as potential threats and the gunners opened fire, killing 37 civilians and injuring 42 others. Kediboni Armed Forces sought alternatives after the Selima Air Force destroyed much of their helicopter fleet in July 2022. They learned about an experimental AI program called Adam during secret talks with Aseroma, which was designed to strike targets autonomously using drones. Adam was made operational in September 2022, and after gathering information on small groups of ULF fighters, it carried out numerous strikes, including one that killed Major Faustino Mabotsi. Adam also struck an abandoned sanatorium and a church where the funeral for Major Faustino Mabotsi was being held. Aseroma's internal documents reveal that Adam software engineers struggled to distinguish between military and civilian targets, but Ms. Lashimongola ordered them to patch the software to prevent accidental targeting of civilians. Selima referred the situation to the African Court of Justice and Human Rights, issued an arrest warrant for Ms. Lashimongola, who had already fled to Bukoda, and requested her extradition, which was turned down. Ms. Lashimongola was not subjected to any criminal investigation by the Kingdom of Bukoda. Ms. Lashimongola was arrested by Bukoda police officers on April 19, 2023, after an arrest warrant was issued by the AFCJHR. She has protested her arrest and denied any wrongdoing. The matter has been brought as a confirmation of charges hearing before the ACJHR with three main agenda items. 1. Whether the case against Ms. Lashimongola of war crimes is admissible before the AFCJHR. 2. Whether there are substantial grounds to believe that the following war crimes pursuant to Article 28D of the Malabo Protocol were committed in Uzuri: A. Unlawful confinement, B. Intentional attacks against planned protected persons, and C. Attacks on protected property. 3. Whether there are substantial grounds to believe that Ms. Lashimongola is individually criminally responsible for war crimes pursuant to Article 46B of the Malabo Protocol. All the three states are members of the African Union and United Nations and have ratified the Vienna Conventions on Law of Treaties, the 4 Geneva Conventions, and the International Covenant on Civil and Political Rights. The Republic of Selima and the State of Kediboni have ratified the Malabo Protocol and the 2 additional protocols to the Geneva Conventions, while the Kingdom of Bukoda has yet to ratify them. The Malabo Protocol came into force in 2019 after ratification by 46 member states.
Okay, thank you so much. So that was a brief of the facts. And before we begin, I would like to request all the spectators, so apart from the judges and the participating teams, everyone else should be muted and their video off. So at this juncture, I would like to first and foremost introduce our judges today. And starting off, we'll start with the President of the Court, Professor Kasim Balarabe. Professor Kasim Balarabe is a professor of law at the Jindal Global Law School. He has research interests in public international law, human rights, humanitarian law, refugee law, international criminal law, and international security issues. He has more than a decade and a half experience in academia, research, humanitarian, legal, and policy development issues. He started his career as an associate at Aluko Ayebode. He later entered the Federal Civil Service, serving as Assistant Chief Legal Officer with Nigeria Federal Ministry of Justice. He was a former Special Assistant Policy to Nigeria's Federal Commissioner for Refugees and represented Nigeria as a delegate to the United Nations General Assembly. He was a research associate with Public International Law and Policy Group in the Netherlands office. Professor Balarabe has also served as a resource for several governmental and non-governmental organizations on human rights, refugees, and humanitarian law issues. He also teaches for the United Nations Institute for Training and Research, UNITA, at Oxford Brookes University in the UK and the Universitat Oberta de Catalunya in Spain. Professor Balarabe holds a Bachelor's of Laws from Ahmadu Bello University, a barrister at law from the Nigerian Law School, a Master of Laws from University of Geneva, a Master of Laws with specialization in law and politics in international security from Vrije Universiteit Amsterdam, and a doctorate in law from Maastricht University in the Netherlands. Our second judge is Ms. Sandra Butcher. Ms. Sandra Butcher is an advocate of the High Court of Kenya and currently an MS candidate in international law at the Graduate Institute of International and Development Studies in Geneva. She has worked as a legal reviewer with the United Nations International Residual Mechanism for Criminal Tribunals, and also as an advocate trainee at Njoroge Regeru and a company advocate. She has previously interned with the International Committee of the Red Cross, ICRC, at the Nairobi Regional Delegation Office, and also with the Kenya National Commission on Human Rights. She was part of the 2014 winners of the All Africa ICRC International Humanitarian Law Moot Court competition. Our next judge is Adjunct Professor Sebastian Lafrance. He is a fellow of the Central Asian Legal Research Center at Tashkent State University of Law in Uzbekistan. He's an adjunct professor at the Universitas Airlangga in Indonesia, an adjunct lecturer at the Ho Chi Minh City University of Law in Vietnam. He's a crown counsel, that is a prosecutor at the Public Prosecution Service of Canada in the competition law section since 2012. He has an LLM in criminal law with honors merit at the Laval University, a Bachelor's of Law from the Law Université de Québec et Montréal, a political science degree at University of Montreal, certificate in Chinese Mandarin at University of Toronto, Russian and Slavic studies at the McGill University. He was a former clerk for the Honorable Marie Deschamps of the Supreme Court of Canada in the period between 2010 to 2011. And he was also an in-house counsel at the law branch of the Supreme Court of Canada in the period of 2011 to 2013. He was a former clerk for the Honorable Michel Robert, the Chief Judge of the Quebec Court of Appeal on the period between 2008 to 2009. He has published more than 50 book chapters and articles in Australia, Brazil, Canada, France, India, Indonesia, United Kingdom, United States, and Vietnam. Our next judge is Dr. Foluke M. Dare. Dr. Foluke holds a PhD in law from Nelson Mandela University, a Master of Laws degree from the University of Sussex in the United Kingdom, and a Bachelor's of Law degree from Igbenedion University in Nigeria. She has a wide knowledge of law, which is evident in her years of legal practice, as well as her lecturing experience. In 2010, she was called to the Nigerian bar as a barrister and solicitor of the Supreme Court of Nigeria. Subsequently, she worked at a law firm of Tayo Jegede and Company, where she represented clients in court, either alone or as a co-counsel in civil litigation, election petitions, and corporate lawsuits. In 2013, she joined the academic field as a law lecturer at the University of Boretland in Zambia. She was one of the law professionals posted on foreign service at Kampala University for 2 years under the Nigerian Technical Aids Corps scheme. During her stay in Uganda, she joined the East African branch of the International Law Association, and was the matron of Forum for Ideas at Kampala International University. After her foreign service in Uganda, she returned to the University of Boretland, where she worked until 2019. In the last 5 years, she has taught various law courses, including international law, international property law, the law of tort, the law of contract, administrative law, criminal law, jurisprudence, and conflicts of laws. In 2016, she published a book titled Terrorism, the Nigerian Perspective, which was inspired by her LLM dissertation. She also wrote 2 articles on Volume 3, Issue 6 of the African Multidisciplinary Journal with the titles A Critical Examination of the Concept of Failed States and Does TRIPS Prevent Developing Countries from Responding Effectively to Health Problems Among Their Population. Her LLD, which is the PhD in law research, focused on the legality of anticipatory self-defense against maritime cyber attack. Our last judge on the panel is Dr. Manuel Brunner. Dr. Manuel Brunner is a professor of public law at the Police Academy of Lower Saxony in Germany. He has also lectured on public international law at the University of German Armed Forces in Hamburg and at the University of Potsdam. He obtained his first law degree at the University of Münster, holds a Master's of Law degree from Maastricht University and a PhD in International Dispute Settlement from the University of Hanover. Dr. Manuel regularly publishes articles and books chapters on German and comparative constitutional law and public international law. So those are the judges we have on our panel. So before we start the session, I will invite Adjunct Professor Sebastian Lafrance, who has a brief introduction to the participants. Prof, over to you.
Thank you very much. Shikamu, habari gani? Jina langu ni Sebastian Lafrance. Nina furaha kukutana na nyinyi. Ni heshima kwangu kuwa hapa na nyinyi leo. Leo ni siku muhimu sana kwenye maisha yenu. Leo ndio siku ya mafanikio yenu. Kwa sababu nyote mulifanya kazi kwa bidii sana. Kama methali inavyosema, penye nia ipo njia. Kila la heri kwa shiriki wote. Asanteni sana. Thank you very much.
Thank you very much, Prof, for that introduction. I'm sure it is from Swahili language. As you all know that now Swahili is the official language of the African Union. So thank you so much. So at this juncture, we'll now start the session. All rise. The African Court of Justice and Human and People's Rights is now in session. Judge President Professor Kasim Balarabe presiding, together with Judge Sandra Butcher, Judge Sebastian Lafrance, Judge Dr. Foluke Meri, and Judge Manuel Bruno. The matter before the court is the situation in Uzuri. The parties are the Office of the Prosecution versus the defense, Ms. Lushomo Ngala. Each team has been allocated 35 minutes of this court's time. Mr. President, over to you.
Thank you, clerk. Before we begin the session, I would like to deliver a very short speech to the participant as well as to us, the judges. Ladies and gentlemen, honorable judges and esteemed participants, I extend to you a warm and heartfelt welcome to the final rounds of our International Humanitarian Law Multi-Court competition. It is an immense pleasure and privilege to stand or to appear before you as the president of the court, and I'm filled with anticipation as we embark on this significant event. Let us reflect for a moment on the journey that has brought us here today, from the preliminaries to the quarterfinals, then the semifinals, and now the grand finale. Your relentless dedication, your commitment to excellence, and your pursuit of justice have been nothing short of inspiring. Each one of you from diverse corners of the globe has demonstrated an exemplary understanding of the complexity and the importance of international humanitarian law. We have witnessed truly outstanding performances, underlining that you are not merely students of law, but indeed future architects of justice. Our esteemed panel of judges, renowned experts in the field of international humanitarian law, have graciously devoted their time and knowledge to this competition. They have brought a rigorous standard of professionalism and intellectual rigor that reflect the gravity of the work we do. We owe them our deepest gratitude. Now, as we head into the finals of this competition, I would like to remind you all of the significance of what we are doing here. International humanitarian law is not just about rules and regulations. It is about safeguarding human dignity in times of armed conflict. It is about promoting peace and justice in the face of adversity. To the esteemed judges, I urge you to carry out your duties with impartiality, wisdom, and discernment. Your role is crucial in evaluating the legal argument presented before you and in assessing the merit of each team's submissions. I trust that your expertise and experience will guide you in making fair and just judgments. To the participants, let us also remember that this is not just a competition. It is an opportunity to learn, to grow, and to challenge ourselves. It is a platform to encourage dialogue, to nurture empathy, and to remind ourselves of the power of law to effect meaningful change in our world. As we proceed, I call upon the participants to abide by all the rules applicable to this competition. Let your argument be passionate but respectful, persuasive but based on fact. Let the spirit of fair play guide your actions. And remember that in the pursuit of justice, it is not just the result, but the means by which we arrive at that result that matters. In the spirit of the law, let this contest be guided by respect for one another, integrity, and adherence to the principles of international humanitarian law. Embrace the ethos of the courtroom, for today, you are not just students or competitors, but advocates for justice. May your argument be cogent, your demeanor professional, and your conduct exemplary. I look forward to witnessing a contest of the highest standard, and may the best team prevail. Let the final round of the International Humanitarian Law Moot Court competition begins. I now call on the prosecution to present their case.
Good morning, Mr. President, Your Honors. May it please this court. My name is Yusuf Jamiu. I appear together with my co-counsel, Mustafa Awao, for the prosecution against the defendant, Ms. Ishomo Ngala. I'll be addressing this court for 12 minutes, after which my co-counsel will speak for 20 minutes. We respectfully reserve 3 minutes for the rebuttal. Your Honors, as an opening statement, the defendant, Ms. Ishomo Ngala, developed and supplied lethal technologies and autonomous weapons to the government of Kendimboye, without which the unlawful assignment of Uzuri residents to their residences, the death of myriad number of civilians, medical staff and patients, as well as the destruction of churches and sanitariums in Uzuri would not have occurred. Your Honors, this act constitutes grave violation of international humanitarian laws. It is in light of this fact that the prosecution seeks to confirm charges of war crimes against Ms. Ishomo Ngala by addressing the 3 substantive issues raised before this honorable court. I'll speak on the first issue, while my co-counsel will speak on the second and third issues, respectively. Your Honors, I'll proceed to make my submission on the first issue. The first issue is whether the case against Ms. Ishomo Ngala is admissible before the FCJHR. The prosecution will address this issue from 2 standpoints. Firstly, the jurisdiction of this court, and secondly, the admissibility of this instant case before this honorable court. On the first standpoint, which is the jurisdiction of this court, the prosecution submits that this court has jurisdiction to entertain this matter in line with Article 3 of the Malabo Protocol. Also, the prosecution submits that all the preconditions necessary for this court to exercise jurisdiction over this matter is also satisfied in the circumstance of this case. Firstly, Your Honors, the subject matter of this case, which is war crimes, as can be gleaned from paragraph 30 of the Statement of Agreed Facts, falls within the crimes listed in Article 28A of the Malabo Protocol, thereby conferring this court with jurisdiction rationale material over this matter. Secondly, as envisaged by Article 46E of the Malabo Protocol, the crimes charged herein were committed after the entry into force of the Malabo Protocol. For clarity, Your Honors, paragraph 31 of the Statement of Agreed Facts discloses that the Malabo Protocol entered into force in 2019. Furthermore, Your Honors, a community reading of paragraph 15, paragraph 21, and paragraph 26 of the Statement of Agreed Facts reveals to this court that all the crimes charged herein were committed in 2022. Hence, this court has jurisdiction rationale temporis over this matter. Thirdly, Your Honors, as envisaged by Article 46E bis of the Malabo Protocol, this court has jurisdiction rationale personally over this matter. For clarity, Your Honors, Article 46 EBs sets out 4 conditions, satisfaction of one of which we confer this court with jurisdiction rationale personally. Your Honors, a careful perusal of the statement of agreed facts reveals that all the of Republic of Salima, who is a party to the Maliboro Protocol, and it is in light of this fact that the prosecution submits that this court has jurisdiction rationale personally over this matter. Lastly, Your Honors, Article 46F of the Maliboro Protocol stipulates that this court will have jurisdiction if one of the 3 conditions stated therein is satisfied. Your Honors, in the circumstance of this case, this matter was referred to the prosecutor by the Republic of Salima, who is a party to the Maliboro Protocol. Hence, the first condition contained in Article 46F, paragraph 1 of the Maliboro Protocol is satisfied. And it is in light of this argument that the prosecutor submits that this court has jurisdiction to entertain this matter. Turning to the second standpoint of this issue, which is admissibility, Your Honors. Your Honors, Article 46H, paragraph 2 of the Maliboro Protocol has set out 3 conditions, satisfaction of which will render a case admissible before this honorable court. Your Honors, the first condition, as can be gleaned from Article 46H of the Maliboro Protocol, is that the state that has jurisdiction must be unwilling or unable to prosecute or investigate the defendant. Herein, Your Honors, the Republic of Salima has the jurisdiction to entertain this matter because the crime charged herein were committed on our territory.
Agent, I have a question, if I may. Judge Lafrance here speaking. Regarding the fact that the point you just raised, is there a timeline that should be observed? Because I understand the state is unwilling to prosecute and there's et cetera, but how long can our court, or should our court, wait until understanding or acknowledging the fact that, okay, this state is unwilling because maybe there is an investigation going on, maybe there will be a prosecution done in the state? So how long is there a timeline, or no, it is up to the discretion of our court to decide, or something? If you can give us some guidance about this.
Thank you, Your Honors. Your Honors, the admissibility of a case as held by the ICC pretrial chamber in the prosecutor versus Ali Hassan, the decision on the admissibility of the charge against the defendant, it was held inter alia by the ICC that admissibility of a case is determined on the factual circumstance of each case. Hence, there is no fixed limit for there to be unwillingness on the path of a state that has jurisdiction over the matter. What the Maliboro Protocol provides at Article 46H, paragraph 3, is that if it's undue delay, a state can be held not to be willing to prosecute. Undue delay is not defined by the Maliboro Protocol. Hence, it is left to this honorable court to determine what amounts to undue delay in the circumstance of this case. Having established that, Your Honor, the contention of the prosecution hearing is that there was inability of a state that has jurisdiction to prosecute. And in the circumstance of this case, and as can be gleaned from Article 28 of paragraph 28 on substantive of agreed fact, the Republic of Salima was unable to extradite Ms. Lishomo Ngala to her territory in order to prosecute her because the Kingdom of Bukada refused their request. Hence, the Republic of Salima is said to be unable to prosecute the defendant in the circumstance of this case. Your Honor,
and if I may ask very briefly, I do not expect, and I don't think my colleague judges expect a long answer to this. It can be a short answer. But do we know why the extradition process was refused by the state, or is there any explanation about this? Being everybody knows the fact here, but could it be explained somehow? You can answer the question from a legal perspective or a factual perspective, or both. It is expected to be very short, doesn't need to be long.
Thank you, Your Honors. Your Honors, in the statement of agreed fact, it was not disclosed why the Kingdom of Bukada refused to extradite the defendant. However, Your Honors, as contained in Rule 6 of the customary IHL rules, every state is under obligation to ensure the prosecution of an individual who is alleged to have committed war crimes. Your Honors, in line with this provision, the Kingdom of Bukada ought to have supported the Republic of Salima in order to prosecute the defendant, but they failed. And this is what
Sorry, Agent, to interrupt you at this stage of your proceedings. Manuel Brunner calling. So you mentioned that every state is under the obligation to prosecute war crimes, right?
No, they are under obligation to aid in the prosecution of war crimes.
Add in the prosecution. Sorry. To add in the prosecution. But like you said, it's a custom, like from the customary rules set out by the ICRC expert study, right? So, but when we look at the practice, so what is actually the international practice in adding in war crimes, in war crime prosecution? Is it like really global practice?
Your Honors, I did not get your question. I'll be glad if you can recapitulate.
My question was the following. So you said it's like a customary principle that you have to add in war crimes prosecution, right? Did I get you right? So as you know, customary international law forms from practice and opinio juris. So how is actually the international global practice, if you look at the practice of different states, in adding to war crime prosecutions? Is it really something really global, which every state practices?
Yes, Your Honors. It is in line with the customary IHL rules that every state is under obligation. And before a rules can become the custom, it has obtained acceptance of the law. And as it is contained in the customary IHL rules, every state is under obligation to aid in the prosecution of war crimes. Proceeding with my argument, having established...
Okay, sorry, Counsel, in connection to that reference to the ICRC study, I just need yes or no answer. To what extent, I mean, is this court bound by that study of ICRC in relations to customary international humanitarian law?
No, Your Honors, this court is not bound.
Okay,
as can be gleaned from Article 31 of the Statute Protocol to the African Court of Human Rights Justice. This court is not bound. It's only persuasive. Proceeding with my argument, Your Honors, having established that the the Republic of Salima is unable to try
Sorry, Agent, to interrupt you once more, but again, to the Honorable President's question. So you are not bound to the study, but I mean, the protocol here is quite detailed and the rules that are applicable are quite detailed. So this court, is it bound to customary international law or just to treaty law?
Yes, Your Honors. If, as regard customary international humanitarian laws, this court is bound by it because it is a source of international humanitarian laws. But as regard ICRC studies, is only persuasive to this court in line with Article 31 of the Statute Protocol to the African Court of Human Rights Justice.
Okay.
Proceeding with my argument, Your Honors, the second condition of admissibility is that the conduct with which the defendant is charged must not have been a subject matter of litigation before now. And as established by the prosecution, the state that has jurisdiction is unable to prosecute the defendant. Hence, it is practically impossible for a defendant to have been tried for this same offense. And it is in light of this exposition that we submit that the second condition is also satisfied. Turning to the last condition.
Counsel, in the light of the questions we have asked you, I've taken note of the fact that your time is off, but I will add you 4 minutes to conclude your arguments. Proceed.
Thank you. Thank you. Turning to the last condition of admissibility, which is gravity, Your Honors. Your Honors, gravity of a case as held by the ICC pretrial chamber in the prosecutor versus Charles at paragraph 11 is assessed from both the quantitative and the qualitative perspective. Your Honors, on the quantitative perspective, it denotes the number of victims of the crime. And here in Your Honors, it was disclosed at paragraph 21 that 37 civilians were killed, 41 were injured, and also at paragraph 26 that churches and sanitariums were destroyed. Unknown medical staff and patients were also killed. Your Honors, in line with the ICC holding in the prosecutor versus Abu Garda decision on confirmation of charges at exactly paragraph 31, the death of 12 victims and injury to 8 was held to satisfy the quantitative threshold of gravity. Your Honors, in light of this decision, we submit that the quantitative threshold of gravity is also satisfied in the circumstance of this case. Turning to the qualitative threshold of gravity, Your Honors, the ICC, the trial chamber 1, held in the prosecution versus Ala Hassan at paragraph 47 that the scale, nature, manner, and degree of participation of the defendant should be taken into the consideration. Your Honors, the prosecution will assess the manner of commission of the crimes and the degree of participation of the defendant. Your Honors, on the manner, as the ICC paper policy on
I have a question, Counsel. I have a little question. It's a yes or no question, so you feel free and welcome to say yes or no and move on to your submission, given the time, the remaining time for your submissions. Regarding the threshold of, is there a death toll or a number of death, a specific number of death that is specified in international humanitarian law that says, okay, beyond this number of deaths, it is of serious gravity, or under this number of deaths of people, it's not. So is there such a specific number? Yes or no?
No, Your Honors.
There
is no specified death number.
Thank you.
To international Moving to the qualitative threshold of gravity, Your Honors, as I've established, it is assessed from both the manner of commission of the crimes and the degree of participation of the defendant. Your Honors, on the manner used herein, we submit that it is indiscriminate as envisaged by Rule 12 of the customary IHL rules. Your Honors, it was disclosed at paragraph 15 that bed target a paragraph 18 of the statement of agreed fact that bed target AI struggled to identify threats when the group of individuals exceeds 50. Your Honors, also at paragraph 24, it was disclosed that Adam struggled to distinguish between military objectives and civilian objects. Your Honors, this act makes the autonomous weapon used to commit the crime charged herein unpredictable, and the ICRC position on the use of autonomous weapon in warfare has ruled out the use of unpredictable autonomous weapons. Hence, the prosecution submitted that the manner used to execute the crime charged herein were indiscriminate. Turning to the degree of participation of the defendant, Your Honors, the paper on some policy issues before the prosecution mandates the prosecution to only charge defendant who is of great responsibility. Your Honors, the defendant herein is of great responsibility, so the crime charge, firstly, she supplied the weapons used to commit the crime. Secondly, the 11 principles adopted by the Convention on the use or prohibition of conventional weapons retained responsibility for acts of autonomous weapons with the developer.
Counsel, I have to stop you. Your time is off.
Yes, yes, Your Honors, in line with the fact that the Convention on Use of Conventional Weapons retains responsibility with the defendant, that is the developer of the autonomous weapon, we submit that the degree of participation of the defendant is high in the circumstance of this case, hence satisfying the qualitative and the quantitative threshold of gravity. In light of this fact, I will defer proceeding to my co-counsel, who will address this court on issue 2 and issue 3 respectively. Thank you, Your Honor.
Thank you.
Your Honors,
Yes.
Can I be heard?
Yes, you may begin, please.
Mr. President, members of the court, may it please the court. As earlier introduced, I am Mustafa Hawa, and I would continue with the prosecution. In seeking to confirm the charges against Ms. Lishomo Ngala, the prosecution, while establishing the war crimes of unlawful confinement, intentional attacks against plant protected persons, and attacks on protected objects, would also prove to this court that there exists the prerequisite mens rea for the commission of the war crimes, and Ms. Lishomo Ngala did incur individual criminal responsibility. If it pleases Your Honor, the prosecution would like to proceed with their submission. As to the first charge of unlawful confinement, the prosecution would approach this charge from two different standpoints. One.
Sorry, excuse me, counsel, just to interrupt you here. Could you please qualify the conflict at hand before proceeding to your argument?
Your Honor, the prosecution submits that the armed conflict in question is an international armed conflict in view of Common Article 2 of the Geneva Conventions of 1949. Proceeding with my argument.
Sorry, please justify.
Yes, please.
Yeah. Great.
Yes,
Your
I was
Honor?
asking you to justify why you think it is regulated by Article 2 common to the Geneva Conventions. Proceed.
Your Honor, in response to your question, we submit that, as can be gleaned from the statement of agreed fact, there has been military occupation by the Kedibonyi Armed Forces, hence classifying it as an IAC, Your Honor. Proceeding with my argument.
Sorry, counsel, to interrupt you, Manuel Brunner here. Hello. So what is the standard for occupation in international humanitarian law?
Your Honors, the ICC commentary provides that the, again, Your Honor, please, can I get the question again?
Yes, of course. There are some technical shenanigans, I think, at the moment. What is the standard for occupation under international humanitarian law? So where we find evidence for it, and what is actually occupation under IHL?
Your Honor, in response to your question, we submit that the ICC commentary on the Geneva Conventions specifically states that military occupations could either be total or partial. In the instant case, which is partial occupation by the Kedibonyi Armed Forces.
Okay, go ahead, please.
Proceeding with my argument, Your Honor, the prosecution shall approach the war crime of unlawful confinement from two different standpoints. One, that the confinement was not conducted in due compliance with Article 42 and Article 43 of the Fourth Geneva Convention. Two, that there exists the prerequisite mens rea for the commission of the war crime in Uzuri, and Ms. Lishomo Ngala did incur individual criminal responsibility via aiding and abetting in view of Article 28N of the Malabo Protocol. Your Honor, the prosecution acknowledges Article 4 of the Fourth Geneva Convention, which provides that protected persons are persons who find themselves in a case of armed conflict to which they are not nationals. We would like to bring to the notice of this honorable court to the decision of the trial chambers in the prosecution versus Tadic 19, wherein such persons were extended to accommodate both nationals and non-nationals. Your Honors, in view of Article 42 of the Fourth Geneva Convention,
Counsel, can you expatiate on that, nationals and non-nationals?
Your Honors, in the instance case, we submit that the Uzurians, the Uzuri is part of Selima. Your Honor, can I be heard?
Yes, go ahead.
Your Honor, we submit that in the instance case, Uzuri is part of Selima and not part of Kedibonyi. And as such, in line with the decision of the trial chambers in prosecution versus Tadic, these persons, whether they are nationals or non-nationals, so long as they are present and they find themselves in a case of armed conflict, they are, but in view of the trial chamber's decision, Your Honor.
Proceeding with my argument, the court said, yes or no? Is that yes, exactly what the court said?
Yes, Your Honor.
Okay, proceed.
Proceeding with my argument, Your Honor, the condition,
sorry, agent, to interrupt you once more. So you said about the status of the territorial status of Usuri. I mean, Usuri changed hands over time, so to say. So from an international law point, to which state Usuri belongs now and why?
In response to your question, Your Honor, we submit that Usuri belongs to Salima. The fact that Kedibonye had military occupation in Usuri does not automatically confers the entire Usuri to the Kedibonye government, Your Honor. Military occupation could be total or partial, even without any resistance of any sort. Proceeding, we submit that the condition placed in Article 42 of the First Geneva.
I'm sorry to interrupt your submissions, Agent. But if I may build on or recall, if I may, my esteemed colleague's question. My question, the question of my colleague was about the legitimacy of to whom it belongs, and not about necessarily the occupation. So what makes that land belong to one state or the other in international, in public international in general, not necessarily in IHL? How can you extrapolate about this, if I may ask? This was the question of my colleague, and I'm not sure if you fully answered it, and I'm really interested as well to know. I'm sure all my esteemed colleagues are as well.
In response to your question, Your Honor, as can be gleaned from the statement of agreed fact, we observe that Usuri voted to be part of Salima. Proceeding with my argument, we submit that Article 42 of the Fourth Geneva Convention has not been complied with, and it states specifically that a confinement is to be conducted where there is reasonable grounds of serious security threat. Your Honors, we submit that the actions of the confined persons did not pose a security threat to the Kedibonye government. Your Honors, while the prosecution acknowledges that the state defines what amounts to state serious security threat in view of the trial chamber's decision in the prosecution versus Delalich, we also submit and contend on similar grounds that merely providing support or aligning oneself with a party to an armed conflict does not automatically make that fall into the category of serious security threat. We also place reliance on the prosecution versus Delalich, 1998, particularly at paragraph 577. Your Honors, we can observe evidence of unlawful confinement at paragraph 13, lines 3 to 5 of the statement of agreed fact, wherein it was stated that, and I quote, these persons were confined to their homes, which was outfitted with special magnetic locks and could only be opened via a smartphone app. Your Honors, in view of all of this, we also submit that the right of appeal, as guaranteed under Article 43 and Article 78 of the Additional Protocol 1, has not been complied with. Having established this, Your Honor, we proceed to Article 43 of the Fourth Geneva Convention.
Sorry,
now,
Counsel,
the provision of Article 43.
I'd like to redirect you back to paragraph 15 of the Statement of Facts. I'm not too sure how you can say that there weren't any appellate or review mechanisms, because we're told that, one, the software didn't make the decisions on its own, and two, the courts were available for any such redress or recourse by the persons afflicted.
Your Honor, in response to your question, we submit, based on factual grounds, that there was no existence of any court. Paragraph 15 simply states that according to Usuri laws, an administrative court conducts the review. It does not specifically state anywhere where this administrative court successfully carried out a review determining the lawfulness of the restriction placed. Your Honor, at the same paragraph 15, it also shows us that the Kedibonye government, who is responsible for conducting the arrest, solely decided and considered whether the restriction placed on these persons should be lifted or not. Your Honors, We submit that at this point, the prosecution may be tempted to prove before this honorable court that the confined persons did engage in hostile activities. However, it is our contention that in view of the ICRC interpretive guide on conduct that amounts to hostilities, that the three cumulative conditions outlined has not been complied with in the instant case. Your Honors, we shall now proceed to establishing the mens rea for the commission of the war crime in Zuri. Your Honors,
Counsel, you cited the ICRC interpretation guide on the notion of direct participation in hostilities, and you mentioned that those three conditions have not been complied with here. Can you address the court on those so we can get your point clear?
Your Honors, in response to your question, one of the conditions is that there must be in existence the required threshold of harm. Your Honors, we submit that the political demonstrations that took place do not and did not adversely affect military operations. In the event that this honorable court finds that this act of political demonstration is participation in hostility, we submit that it constitutes indirect participation in hostilities. And as such, the effect of indirect participation in hostilities does not render the protected status of these persons to a nullity. With respect to the second and third conditions, which is a direct causation between the act and the likely harm, and the existence of a belligerent nexus, we submit that the political demonstrations, the sit-ins and everything was just a manifestation of their freedom of expression as guaranteed under Article 19 of the International Covenant on Civil and Political Rights. Proceeding with my argument, Your Honor, in order to establish...
Sorry, Agent, to interrupt you, but is this the three-pronged test from the ICRC concerning DPHing? Is this agreed in international law? I mean, has it found its way into custom, or is it, or what is the status of this three-pronged test?
The status of the ICRC regulations constitutes publicist opinion, and they are accepted in view of Article 31 of the Malabo Protocol. Your Honor, proceeding with my argument, in order to establish mental elements.
Sorry, Agent, to interrupt you once more, but is it really like the statement of this expert view? Does it have what is the legitimacy of this kind of view? I mean you said, yeah, we have to look at it, but why exactly? Why exactly is this ICRC DPHing test, like, why should we even look at it?
Your Honor, in response to your question, we submit that this ICRC opinion paper is just a publicist opinion and hence is not legally binding on this court, merely persuasive. Proceeding with the mens rea for the commission of the war crimes in Missouri, we submit that in view of the Prosecution versus Tadich 1997, in order to establish knowledge and intent, there must be adequate awareness of the act coupled with the intention to participate in the crime. As can be gleaned from paragraph 14 of the statement of agreed fact, particularly lines 2 to 4, we observe that there had been extensive discussion by the California government with the defendants on the use of Afro-Opt to monitor a large group of persons. Your Honor, none of the commission of this crime is also inherent from the statement of agreed fact, wherein Afro-Opt was being used to unlawfully confine these persons. Now, with respect to the individual criminal responsibility of Ms. Lushomo Ngala, in the prosecution, in the ICC Appeal Chamber's decision in Prosecution versus Bemba 2018, it has provided 3 cumulative conditions that define aiding and abetting. One of the conditions is that the act must facilitate the commission of the crime. And it is our submission that Ms. Lushomo Ngala provided Afro-Opt, a software program used to restrict the movement of people in order to aid and facilitate the commission of this war crime in Uzuri.
But
With respect to the second
I'm
condition,
sorry, Agent, but did she have the intention to assist with this program to kill people and to kill civilians? Was that her intention when she worked on this program?
Your Honor, in response to your
Sorry,
question,
in connection with that, I want to perhaps to combine the answer and then inform us. What type of mens rea is required for this particular, offense? So combine that question with the one asked by my colleague to respond to us.
In response to your questions, Your Honor, we submit that knowledge and intent is the prerequisite mens rea required here. As shall be seen subsequently in the course of my argument with respect to the second charge, Your Honor, Ms. Lushomo Ngala had the prerequisite knowledge and intention to have directed an attack at these civilians. Your Honor, we submit that in view of the statement of agreed fact, Ms. Lushomo Ngala was very much aware that
I'm sorry, Agent, would it be direct intention or rather indirect, or can it be inferred that she had the intention of doing so, or is there anything in the facts that would support the fact that it was a direct connection between this, or it must be inferred instead?
Your Honor, we submit to this court that it is to be inferred. Your Honor, from the statement of agreed fact, we realize that Ms. Lushomo Ngala, being the software developer of bird targets, was very much aware that bird targets may become overloaded. Despite this inherent warning, she did not back out and instead handed over this defaulting AI to the Kedibonyi Armed Forces, hence construing intent on her own part to have launched an attack at these civilians. Proceeding with my argument, we conclude on the whole that...
Sorry, Agent, I also have a question. At multiple times in your presentation now, you refer to the freedom of opinion, freedom of assembly, and freedom of movement. At the same time, you argued that the territory in question is occupied. So I will lead you to the opinion of the state of Israel. Israel argues in occupied territories, human rights law is not applicable. Is that view correct under international law?
Your Honor, could you please rephrase the question?
Yes. So is like, say, is human rights law in occupied territories, is it applicable?
Did you get the question?
In response, yes, Your Honor. In response to your question, we submit that human rights law operates as lex generalis, while international humanitarian law acts as lex specialis, that is, it's peculiar to armed conflict. And as such, human rights law does not govern armed conflict. Proceeding with my argument, we submit
the question is, do you agree that human rights law is not applicable to situations of armed conflict, or specifically situation of belligerent occupation?
Your Honor, in response to your question, we submit that human rights law do not apply in armed conflict. Rather, international humanitarian law operates as a lex specialis to armed conflict. Proceeding with my argument, we submit that Mr. Shomo had the prerequisite knowledge that Afro-Opt...
Sorry, Agent. You said international human rights do not apply in armed conflict. Is that correct?
Your Honor, human rights do not apply in armed conflict. But
at the same time, you argued that that people have human rights. So how does this go together?
Your Honor, in response to your question, the prosecution made the submission with respect to the freedom of expression just to establish that they are entitled to this right. However, the war crime in question is that of an unlawful confinement, which is peculiar to armed conflict alone. Proceeding with my
Agent,
argument.
You have 4 minutes to conclude your arguments.
Noted, Your Honor. Your Honor, with respect to intentional attacks on plant protected persons, we submit that the attack was directed at civilians.
Sorry, Agent, to interrupt you once more.
Your Honor?
But when, okay, you said, but where then is the freedom of movement then regulated in IHL? When human rights law is
Your
not
Honor?
applicable, where is it regulated?
Your Honor, could you please rephrase the question?
Yes. So you said the freedom of opinion was just an example, and you are talking here about confinement. The confinement, talking the language of human rights, is a restriction of the right to liberty, or the right to move, to freedom of movement. So when human rights law, as you stated, is not applicable in armed conflict, then in order that there is a restriction of the freedom of movement, there must be something in international humanitarian law that says people are entitled to the freedom of movement. So where can we find that?
Your Honor, as earlier submitted, Article 42 of the 4th Geneva Convention provides for the 4th Geneva Convention provides that persons should not be unlawfully confined unless there is reasonable grounds of a serious security threat. Proceeding with the second charge of unlawful confinement, we also submit that there was a direction of attack.
I'm aware of time, but I'm also just finding it difficult to accept your argument and inference, because I mean, looking at paragraph 14 of the statement of facts, the use of abrupt in Uzuri was never mentioned during the meeting. So I'm left to question where exactly the inference is made.
Your Honor, in response to your question, the prosecution acknowledges that the use of Afro-opt in Uzuri was never mentioned to the defendant. However, she is the software developer and hence has the knowledge that Afro-opt has the inherent ability to be used to confine persons and restrict their movement. Proceeding with my argument on the second charge of unlawful confinement, we submit that the civilians were indeed directed with an attack. Your Honors, Article 51 of the Additional Protocol 1, Article 15 sub 1 of the Additional Protocol 1, and Article 15 sub 4 of the Additional Protocol 1 provides for the protection of civilians, medical personnel, and religious units. It can be gleaned from the statement of agreed fact that there was a direction of attack at these persons, particularly at paragraph 21, where the civilians were directed with an attack by bird targets, killing 37 civilians and injuring 42 others. We also observe at paragraph 25 and 26, respectively, where medical personnel and religious personnel were directed with an attack. Moving to the individual criminal responsibility of Ms. Lushomo Ngala, we submit that Ms. Lushomo fits perfectly into the constituents of aiding and abetting. Your Honor, as earlier submitted, she was very much aware that bird target had that defect of being overloaded when the range of individuals exceed 50. We also submit that, but for the assistance of bird targets, the war crime of directing an attack at civilians could not have been committed in Uzuri. Your Honor, moving to the next charge of attacks on protected object, we also submit that in view of Article 28D of the Malabo Protocol and Article 53 of the Additional Protocol 1, it provides for the protection of medical units and religious buildings. Your Honor, the defense may be tempted to prove that these objects are military objectives. However, in view of Article 52 of the Additional Protocol 1, we submit and contend that these objects are not military objectives and they do not fit into the criteria outlined in Article 52 of the Additional Protocol 1.
Your time is off.
On the whole, we submit that Ms. Lushomo Ngala is individually criminally responsible for the attacks on protected persons by providing ADOM, a defective AI which had problems distinguishing civilian objects from military objectives. Despite this knowledge, she instructed that this AI should be handed over to the Kedibonyi Armed Forces. This is also being aware that ADOM would be used aerially via the use of drones. Noted, Your Honor. In view of all of this, we submit that the war crimes of unlawful confinement, intentional attacks against plant protected persons, and attacks on protected objects were committed in Uzuri. and that Ms. Lushomo Ngala did incur individual criminal responsibility via aiding and abetting in view of Article 28N of the Malabo Protocol. I may be of any assistance to this court. May it please the court.
Thank you. Thank you. I now invite the defense to open their arguments.
Your Excellencies, ladies and gentlemen, good morning. My name is Njoroge Kiania. I shall be the lead counsel for the defense. I shall take 12 minutes, while my co-counsel shall take 18 minutes. Your Excellencies, before this honorable court is an AI visionary, an entrepreneur, an employer who we submit does not bear individual criminal responsibility for any of the events that took place in Uzuri. Your Excellencies, I shall be handling issue 1, where we shall submit that the matters before this honorable court are inadmissible. And should this honorable court, in its wisdom, find that the matters before it are admissible, then my co-counsel will go on to submit that the war crimes, that no war crimes took place in Uzuri, and that Ms. Lushomo Ngala is not individually criminally responsible. Your Excellencies, the defense does not wish to contest the jurisdiction of this honorable court, which is provided for under Articles 3, 28A, and 28D of the Malabo Protocol. However, we do contest the admissibility of issues before this honorable court on 2 grounds. The first ground will be that the matters before this honorable court lack the requisite gravity to be adjudicated by this court. And on the second ground is that the complementarity doctrine pursuant to Article 46H of the Malabo Protocol has not been adhered to. On to the first limb of my submission, that the matters herein do not hold the requisite gravity. Your Excellencies, in the case of Abu Gada pretrial chamber decision, it laid out some indicators which state whether a matter before a court such as this hold the requisite gravity. It stated the nature, the scale, the impact, and the manner in which the alleged crimes were committed. Your Excellencies, the same Abu Gada case in the pretrial chamber as the defense have submitted, the defendant was held liable for the deaths of 12 UN peacekeepers and the injury of 8 more. However, the court held that in this case, despite this number being small, the gravity threshold had been met, as these were UN peacekeepers. And the effect of the deaths of these UN peacekeepers had the effect of destabilizing the security in the region, therefore having a huge impact on the community. In this case, however, the consequential deaths of the civilians in this case do not have a ripple effect on the community, and therefore the impact that the members of the community face as to the deaths of these civilians cannot be compared in any way to the scenario in the Abu Gada case, as the defense have submitted.
Yeah, sorry, agent, to interrupt.
Okay.
But is then your argument that the lives of UN peacekeepers are worth more than the lives of let's say ordinary civilians? So is that the argument?
Your Excellencies, we do not submit, as the defense, we submit that all lives are equally important. However, the effect of the loss of lives has to be looked at.
Sorry, agent, to interrupt you once more. I go with your argument, of course, that all lives has the same importance. Do you have evidence for it in international law, that all lives are equal?
Pardon, Your Excellency?
I go with your view that all lives are of the same importance. Yeah. Do we have evidence in law, in international law, that all life is to be treated the same?
Customary international law rules hold that each individual has inherent human rights. However, in some situations, such as this, as we are submitting, the value of a life is different, because in this case, these are UN peacekeepers whose effect is to protect the lives of thousands more. therefore, we submit that we do not submit that these lives are not important. However, the effect of these deaths cannot be matched to the effect of the deaths in the Abu Ghada case.
May I ask you a question? What yardstick are you using to judge the effect of the death toll in determining whether it's significant or not?
Your Excellency, the yardstick that is used is on a case-by-case basis. In this case, these were protesters. They were not UN peacekeepers. They were not crucial medical personnel. Therefore, in this case, they were not the top political brass who in effect will lead to the loss of many more lives if they were killed. And therefore, we submit that these were protesters.
Sorry, agent. If I may jump in at that point, but you said there were just protesters. So the freedom of assembly had been held. Oh, okay. Once more after the interruption. Sorry. I guess the president will grant some extra time after this. So once more. So you said there were mere protesters. So protesters. So they taking. They're enjoying their right to assembly, and multiple human rights institutions as well as national courts have held that the right to assembly is actually something of a high value in a democratic society. So how can you reconcile this position with what you just said?
Your Excellencies, as my co-counsel will submit, we submit that these protesters, they were indeed peaceful protesters and their rights were protected. However, they started throwing stones at the at the KAF troops. And this, as my co-counsel will submit, surmounted to direct participation in hostilities. And therefore, this right to assembly was waived in this scenario in respect to these protesters.
Thank you.
May I just quickly add that do they lose their rights to life by virtue of the fact that they participated in a degree of protest through their conduct? Does that mean they automatically forfeit their rights to life or their right to be protected?
Your
Or is that a
Excellency,
justification? Is that a justification for them to be targeted? I'm just curious about your thoughts on that.
Your Excellencies, it is our submission that protected persons do not lose their protected status if and until they take part in direct hostilities. And in the case where they cease taking part in hostilities, their protected status is restored. In this case, these protesters were taking part in hostilities, as my co-counsel will submit on it. And therefore, we submit that the right to assembly of these people and their protected status was waived at that moment.
Sorry, agent. Just that the Honorable Judge Dr. Dare and myself, that we have clarity. So you said we get from your presentation, I think Dr. Dare also, that you refer all those issues to your co-counsel, right?
Yes.
Okay, then go ahead, please.
Your Excellencies, further, in the case of Prosecutor versus Lubanga, the pretrial chamber also held that in situations such as this, those who are most responsible for the crimes are the ones who are to be charged before an honorable court. In the case of Prosecutor versus Enver and Amir Kabura, it laid out some threshold on who are these superiors. In this case, it laid out that when a superior is liable for the acts of its subordinates, when they had control over these subordinates, or they had knowledge as to the acts of...
Agent, I have a quick question to ask you about this. Is there and if you don't know, it's fine, it will not be prejudiced against you. It's just to check, just to know if you know it. Is there a Latin specific expression that applies here, a Latin legal expression that applies to the concept of the superior or control of the superior in this case that is used commonly in international humanitarian law?
Your Excellency, I'm not familiar with the Latin term, maybe the English term.
Okay, thank you.
Your Excellencies, in this case, pursuant to paragraph 14, line 3 of the fact pattern, in the case of AFROPT, we are informed that Ms. Mongala was not informed that Kedibonye. Further, in paragraph 18 of the fact of the statement of relevant facts, we are informed about the use of bad target AI, in which the Asayaroma internal memos were shared with the Kedibonye Armed Forces, informing them that such software will be overridden in case of it will be used in places with more than 250 people. Therefore, we submit that Ms. Lusho Mongala and her responsibility over the AI developed by her company ended at the point of handover, to the Kedibonye Armed Forces, and therefore the individual criminal responsibility under the superior subordinate relationship in this case does not exist.
Sorry, Agent, to interrupt you, but this is, I mean, is this a new technology for the armed forces, right? I mean, it's not that the armed forces are handling AI on a regular basis. So does this responsibility really ends there?
Your Excellency, we submit that indeed the responsibility ends because, for example, in paragraph 18, we learned that she communicated on the limitations of her technology, and therefore she extinguished her duty of informing these people that this technology indeed has limitations, and these limitations should be adhered to in the rollout of their technology.
Okay.
On the complementarity doctrine, we submit that Article 46H in its sub-article 1 states that this honorable court shall have complementary jurisdiction to that of national and regional courts. Further, in its sub-article 2, it gives scenarios in which a matter may be declared inadmissible before this honorable court. They include where prosecution, investigations or prosecution are currently ongoing, and by a state with competent jurisdiction, or when a state with competent jurisdiction has decided not to prosecute, or where a defendant...
Counsel, you have 4 minutes to conclude your arguments.
Much obliged. Or where an accused has already been tried of the matters herein, or when a matter lacks sufficient gravity. Your Excellencies, on the first 2 thresholds, that if a matter is being investigated or prosecuted, on the second limb of those provisions, is the provision of unwillingness or inability. We submit that 1, pursuant to paragraph 15 of the fact pattern, we learn that that the Uzuri courts are impartial and are independent, and therefore we submit that these courts were not granted the opportunity to try Ms. Lusho Mongala if necessitated in the first place. We also submit that the declining of Bukada to pursuant to paragraph 28 of the fact pattern to issue a warrant of arrest against Ms. Lusho Mongala is because the Salima wanted to conduct investigations against Ms. Lusho Mongala as regarding her provision of weapons and ammunition to an adversary. And the investigations did not include war crimes. Therefore, the Republic of Salima, even where it deems itself having jurisdiction to hear the matters here, in which we submit it cannot be heard by the Salima courts, the courts made no attempt. They did not make an attempt at trying her before the national courts.
Counsel, I have a question for you. Going back to your initial arguments on the equality of right to life, where you cited or you made references to the peacekeepers, and also a question was thrown to you relating to whether their lives should be considered more valuable, more important than the lives of the civilians. I would like you to address me on to what extent do you think the principle of proportionality in international humanitarian law is applicable to that situation that will warrant considering the lives of the civilians that have been lost, to be more justified?
Pardon, Your Excellency?
Yes, I want you to address the court on the applicability of the principle of proportionality to that particular incident.
Much obliged. Your Excellency, we submit that proportionality is one of the most core tenets of international law. And in this case, proportionality under Article 57(1) of AP1 dictates that when a force is used, it must be commensurate to the military advantage seeking to be gained. In this case, Your Excellency, the Uzuri protesters, as pursuant to paragraph 14 of the fact pattern, the ULF distributed pamphlets to these protesters, and these protesters, in essence, they became voluntary human shields to the ULF to impede the military operations of the Kedibonyi Armed Forces. And therefore, we submit that the doctrine of the principle of proportionality, in this case,
but making them, if I may interrupt you politely, does it make the people who were, that you say are considered as human shield, does it take away their status as civilians under IHL?
Your Excellencies, not only did these protesters become voluntary human shields, they went as far as taking part in direct in hostilities. In effect, that they threw stones towards the
but that's it. They threw stones. Like, they didn't use guns or rifles or grenades or bombs, right? They threw stones. So can you bring our attention in the facts where the fact of simply throwing stones, how can you qualify? Let me rephrase. How can you qualify this incident or these incidents of throwing stones as being serious enough?
Your Excellency, this was a crowd of 250 people. The KAF had not anticipated that there would be barricades on their way to on their military operations. And therefore, they are not prepared to encounter such protesters. And in this case, they had no other means of quelling the unrest that arose due to the throwing of stones of the protesters. And therefore, we submit that in this case, because it will had they not retaliated, it would have led to the further loss of KAF forces. And Your Excellencies, we also submit that the gunners only opened fire after a ULF fighter wanted to shoot an RPG, a ULF fighter who in fact had been harbored by the protesters in their communities.
Thank you. Just a quick question. Oh, sorry, Mr. President.
No, go ahead. Go ahead.
Just a very quick question, building on the question I just asked you. So bring you back to the question of status. Did the civilians in this case become soldiers because of throwing the stones, or they remained civilians under IHL? So was there a change of their status or not?
Your Excellency, we submit that they remain civilians. However, their protected status of civilians was extinguished for that period of time that they took part in hostilities.
Okay, though you have mentioned that your co-counsel will address the court on the direct participation issue, but I have two quick questions for you. I understand that your time is off, but I will allow you to answer these questions. They are very short, and I will appreciate if you can give us very short answers. The first one is you refer to them as voluntary human shield. To what extent do you think they are acting voluntarily? That is one. Secondly, I also like you to answer this question, the extent to which you think human rights law is applicable in armed conflict situation.
Your Excellencies, on the first question, we submit that as these protesters were handed pamphlets, they were not forced on the streets, they were handed pamphlets and encouraged by the ULF to erect barricades against the KAF forces, which in essence led to a military advantage of the ULF against the Kedibonyi armed forces. On to the second question on the application of human rights law. International human rights law, indeed, it applies universally. However, international humanitarian law is the most addresses situations in armed conflict in depth compared to international human rights law. However, international human rights law must always be adhered to even during armed conflict.
Do you have any reference that you can cite here?
Excellencies, I'd like to cite the ICRC guidebook on customary international human rights law.
Okay, thank you. Your time is.
I wish to cede floor to my co-counsel.
Yes, please proceed.
May it please this honorable court, your excellencies, and for purposes of record, my name is Counsel Hope McKenna, appearing for the defense. I stand today as part of the legal representatives of the defendant who has been accused of grave charges, including war crimes, violation of human rights, and individual responsibility. No one shall be condemned unheard, your excellencies. The African Court of Justice on Human Rights serves as the guardian of justice, fairness, and the protection of human rights. We shall contest the notion of the individual criminal responsibility and demonstrate that our client should not bear the sole burden of accountability. It is crucial to consider the wider context in which these alleged crimes occurred. Moreover, we intend to present evidence that challenges the allegations of war crimes, attacks on personal property, protected persons, and violation of human rights. In light of the above, I will be tackling issues 2 and 3. It is our submission, therefore, under issue 2 as the defense that there lacks substantial grounds to believe that the war crimes pursuant to Article 28D of the Malabo Protocol were, as a matter of fact, committed in Uzuri. The Article 28D of the Malabo Protocol provides for the grave breaches of the Geneva Conventions, and under this, it provides for unlawful confinement, it provides for intentional attacks on protected persons and attacks on protected properties. It is our submission as the defense that these crimes did not actually occur in the region of Uzuri. Your Honor, on to the first issue, which is unlawful confinement, we'd like to give mention to the provisions of Article 9 of the ICCPR being read together with Article 6 of the African Charter on Human Rights. Your Honor, under Article 9, it provides for the right to liberty and security of a person, but this right is a limited right by the procedures of law. I'd also like to give mention to the Article 42 of the 4th Geneva Convention. Under Article 42 of the 4th Geneva Convention, it provides that in the instance where a person is to be kept and detained in unassigned residences, the detaining power should deem it absolutely necessary for this person to undergo this detention. Your Honor, I would like to now give mention to the case of Prosecutor versus Delilac, 2001 in the Appellate Chamber of the ICTY, Your Honor. In this case, it was stated that there has to be reasonable grounds of security of the state which is making such a decision. And Your Honor, it is our submission as the defense that indeed there are reasonable grounds as to why the people who are confined in the region of Uzuri were indeed detained. The trial chamber found that the detention is only permissible and it will be unlawful if these people are not going to be detained with legitimate reasons, and these people are not going to be allowed a period where that detention is going to be reviewed. That being said, Your Excellencies, I would like now to direct this honorable court to the fact pattern under paragraph 4. Under paragraph 4, Your Excellencies, we see that the ULF forces had actually launched attacks against the Kedibonyi government. We see them launching missile attacks in the surrounding villages. It is also stated that under paragraph 5 that this ongoing war was for a period of 2 years, of 20 years, Your Excellency. For 20 years, the ULF forces have been launching missile attacks against the
the communities which surround the Kedibonye government. Your Excellencies, I'd also like us to take note of paragraph 8 of the fact pattern, which states and shows clearly that the ULF forces through Asadat, had controlled and gained support from people, whereby they go ahead to take over government buildings, throwing of stones and projectiles to police officers in that region. Your Excellency, it is our submission as a defense that when the Kedibonye government detained these people, they did it with serious and legitimate reasons, because clearly we see that the security of the people in those villages and the security of police officers in this...
Counsel, if I may, Agent, if I may interrupt you very politely here. What is the legal standard? I understand you mentioned that. Okay, can you just identify the legal standard shortly about what you just said? The legal standard that applies to the you were talking about the civilians that threw stones and so on in this case. So can you identify, and you mentioned a few legal terms, but can you specifically identify the legal test or legal standards that applies here to the case? To what you just said.
Much obliged, Your Excellency. I'd like to give mention to participation of direct hostilities. In this scenario, we see that the civilians in question who are actually arrested and detained had indeed taken part in direct hostilities when they decided to throw stones and various projectiles at the police officers who are trying to control the protests that are occurring in Uzuri. Giving mention to the case of Prosecutor versus Gaelic in the trial chamber of the ICTY, it explained that direct participation in hostilities is an act of war by which the nature and the purpose of it is likely to cause harm to the personal or material opposing forces, which one's forces are engaged in combat. In this scenario, the supporters in this question, the Protestants in this question, had indeed been supporting the ULF. They had thrown stones and projectiles and had interfered with a military operation in order to protect the ULF forces who are taking charge in carrying out missile attacks against the government. That being said, I wish to proceed, Your Excellencies.
Thank you.
As I was mentioning, the confinement that was being done in the region of Uzuri was in no way unlawful, because the government of Kedibonye had legitimate and serious reasons to carry out this confinement.
Sorry, Agent. Before you continue, you mentioned some minutes before that there's a war going on for 20 years. So could you elaborate on the concept of war in international humanitarian law vis-a-vis the concept of international armed conflict?
Much obliged, Your Excellencies. I'd like to give mention that the war that's going on in the region of Uzuri is a matter of fact, non-international armed conflict, due to the fact that the mere reason that Kedibonye government had given legislative and administrative autonomy to the region of Uzuri does not mean that the region of Uzuri now becomes a state. And therefore, as stated during the pre-colonial times, the region of Uzuri is still part of Kedibonye. And therefore, the ULF attacks are seen as a terrorist attack against the government of Kedibonye.
Yeah, I get this. Thank you for this detailed explanation. But then my question is, what is the difference between war as a concept in international humanitarian law and international armed conflict? Is there a difference between
the term war
and international armed conflict?
The term war was replaced with the term armed conflict in the Geneva Convention. Therefore, it is our submission that there was indeed war going on, but because in the Geneva Convention does not specifically term war, it has stated the presence of armed conflict. Therefore, it is my submission that in this...
Sorry, Agent, but could you lead us to the reference for this?
I would like to mention that under the Geneva Conventions, under Common Article 3 and Common Article 2, it provides for non-international armed conflicts and international armed conflicts, which in this case would like to interpret them as being war.
Okay, go ahead.
Much obliged, Your Excellencies.
In connection to that, if I understood you well, it's like you have qualified the conflict in this situation as non-international armed conflict. Was I correct?
Yes, Your Honor.
Okay, then what will you say to the situation of occupation that has been in existence for years?
Much obliged, Your Excellency. As provided for under the fact pattern, Your Excellency, before the government of Kedibonye and Salima were colonized by the kingdom of Bukada, Uzuri was a part of Kedibonye, but it was only during colonization that Uzuri became a part of Salima. After colonization, Your Excellency, it wasn't stated whether Uzuri would become part of Salima or part of Kedibonye. And therefore, we also see the government of Kedibonye giving Uzuri autonomy, but this does not mean that Uzuri becomes a state. It is still merely a part of the territory of Kedibonye.
Right. I got that. But then what will you say to the international law position regarding the status of a territory at the time of independence? Can there be any change in the status of a territory after independence, even though as you are suggesting now that the country or that particular part of the country, Uzuri, does not, the fact that it has been given administrative rights does not really qualify it to be a country. What do you think international law says regarding the status of a territory at the time of independence, and what effect will it have after the independence?
Your Excellency, if you wouldn't mind, I'd like you to kindly rephrase your question.
Okay. You considered Uzuri as part of Kedibonye?
Yes, Your Excellency.
And your argument was because it was part of that country before colonization. And from the agreed fact, we have seen that the status of the territory of Uzuri has changed at the time of independence.
Yes.
Am I correct?
Yes,
okay.
Your Excellency.
So now that was the time of independence, and you are now qualifying the conflict as non-international because you still considered Uzuri as part of Kedibonye. Is that correct?
Yes, Your Excellency.
So what happened? What is the legal status of aligning Uzuri to be part of Salima at the time of independence?
Your Excellency, Uzuri, during the time of colonization, we saw that Uzuri was actually a part of Salima. But after colonization, the government of Bukada, the kingdom of Bukada, left for a referendum to be carried out. But Your Honor, it is clearly seen that the government of the region of Uzuri was still under the reins of the government of Kedibonye, and it has not yet expressly been stated that Uzuri is a part of Salima in this question.
Wasn't it because of the conflict where Kedibonye invaded that particular territory that it had, the opportunity to control it? And the fact of the case indicated it was a situation of occupation.
Much obliged, Your Excellency. It is our submission, therefore, as the defense that the region of Uzuri, due to the fact that it was originally a part of Kedibonye, was meant in the legal status of Uzuri had not changed after colonization, because before colonization, Uzuri was still a part of Kedibonye, and therefore it was only proper that after colonization, it be deemed so, Your Honor.
Yeah, sorry, agent. Sorry, agent, to interrupt you. But how do you reconcile that with uti possidetis juris?
Pardon me, Your Excellency.
Are you familiar with the term uti possidetis?
No, Your Excellency.
Okay, then go ahead, please.
Much obliged, Your Excellency. Would like to give mention that occupation of a nation does not necessarily change the status of that region. Your Excellency, moving forward, I'd like to give mention also.
Just to go back to this nature of conflict, I'm just curious. You said it's a non-international armed conflict, but does the nature of this conflict change as the fact sheet progresses? And I'm making reference here to paragraph 16 of the statement of facts, where we can see Salima forces supplying the ULF with rocket-propelled grenades. Would any such action, for example, change the nature of the conflict?
Much obliged, Your Excellency. It is our submission, yes, that indeed, during the beginning of this, especially when unlawful confinement was occurring, it was a non-international armed conflict. But during the progression of this conflict, it changes to become international due to the interference of Salima, which is a state. Salima now changed an international armed conflict by providing against the government of Kedibonye.
Sorry, if you can hear me, is there a term we could
May I
use
proceed, Your
to,
Excellency?
just a second. Is there a term we could use to qualify such interference by Salima under international law?
Much obliged, Your Excellency. As for now, we do not have any term to give this honorable court. I am not familiar with any term.
Okay, proceed, Counsel.
Much obliged, Your Excellency. As I was mentioning earlier, under paragraph 12, we see that the government of Kedibonye indeed confined these people in assigned residences. But furthermore, the government went a step ahead to make sure that in as much as these people were confined, they were still treated in a humane manner. This is to show that the people are allowed to have medical attention, they're allowed to go out for recreational activities. And in line with Article 43 of the 4th Geneva Convention, the government of Kedibonye allowed appeals to be given to the courts in Uzuri. This is to mean that under Article 43, it provides that these appeals and this reconsideration should be made after a period of 6 months yearly. But the government of Kedibonye went a step further and allowed these appeals to be taken and this reconsideration to be taken after every 3 months. In no way did it occur in the region of Uzuri. On to the second issue, Your Excellencies, I would like now to discuss the issue of intentional attacks against plant protected persons. Article 4.
Counsel, is there anything that you can refer to as in the fact of the case where this 3-month review was carried out, even at once?
Much obliged, Your Excellency. We do not have, we just know according to the fact pattern under paragraph 14 that the government had accorded these people the right to have their detention reconsidered after 3 months and to have a chance to appeal to the courts of law in the region of Uzuri.
Proceed.
Much obliged, Your Excellency. Proceeding over to the second issue, which is on intentional attacks against plant protected persons. Article 4 of the 4th Geneva Convention provides that plant protected persons are people who find themselves in a time of conflict or occupation. These people include, but are not limited to, medical personnel, religious staff, human aid staff, civilian populations, and many others. Your Honor, we do recognize the provisions of Article 13 of the Second Additional Protocol, which provides that caution should be taken to spare civilian lives during the carrying out of military operations. The same is echoed under Article 48 and 51 of the First Additional Protocol. However, Your Excellencies, we'd also like to give mention to Article 51.7 of the ICCPR, which states that and dictates that the presence and movement of civilian population should not impede military operations and attempt to shield military of the adversary during attacks. We also see in Article 21 of the ICCPR that it promotes peaceful assembly among advanced 17 of the fact pattern. We are informed that the ULF fighters had taken an opportunity to blend with the people who are present in the region of Uzuri. The ULF fighters had integrated the people of Uzuri, and the KAF forces had taken precaution pursuant to Article 13 of the Second Additional Protocol to protect the civilians to the extent that they deployed the use of bad target AI, whereby they were able to distinguish civilians and the military personnel who are part of the ULF. Your Honor, this is something that the KAF did because they highly valued the lives of the civilians in that region. Furthermore, we see under paragraph 20 and 21 that while the ULF were approaching Old Town Plaza, the KAF soldiers—
Just to take you back there, even in paragraph
obliged.
18, I'm struggling to see how the Kedibonye armed forces value the life of civilians when they were aware that the accuracy of targets rather beyond a group of 50 people would be faulty.
Much obliged, Your Excellency. It is our submission as the defense that before the KAF approached Old Town Plaza, they had not anticipated a crowd of 250 persons. However, in paragraph 18, the reason why KAF deployed the use of bad target AI was in order to reduce the loss of lives that were caused due to the integration of ULF fighters in the community with the civilians of that region, Your Excellency. As soon as my time is up, I'd like to request this honorable court to allocate me more time for my submission.
One more question. Oh,
You
sorry,
are given 4 minutes.
One more,
Much obliged, Your Excellency.
one more question. I mean, I mean, in the end, and this leads back to my esteemed colleague Sébastien Lafrance's question from the beginning, from your co-counsel about throwing rocks. I mean, what we see there, it's not uncommon in violent protestation. So what other means than lethal force could the military forces have employed in order to get the riots under the riot situation under control?
Much obliged, Your Excellency. It is our submission as the defense that.
Sorry, excuse me, sorry to interrupt you. May I just add so that you may answer together? Just a quick question just in line with the question I was just asked. What is the justification for the use of force against these civilians? And to what extent do you think Miss Ngala, to what extent do you think she was responsible pertaining to the standard of software? I've seen that you've argued that her responsibility ends at the point of handover. But to what extent do you think her responsibility might extend by way of her duty to provide a software that was up to standard?
I'm much obliged, Your Excellency.
Go ahead.
Much obliged, Your Excellency. Over to the first honorable judge's question, I'd like to submit that the people in the region of Uzuri, that mountainous region of Uzuri, the people in Old Town Plaza had deliberately taken action to allow the ULF to be integrated with them, thus putting them at risk. Furthermore, once they were handed over templates and pamphlets to show that they should demonstrate, they accepted. This is to show that the civilians in that region had actually accepted the movement, which was being carried out by the ULF, and were taking opportunities to impede the military operation being carried out by the government of Kedibonye. To the second honorable judge's question, it is our position as a defense that Mrs. Lushomo Ngala shouldn't be held responsible for the deaths of the 37 and 42 by the usage of her AI, due to the fact that Mrs. Lushomo Ngala, at the point of handover, had made sure she had expressly stated to the KF fighters the limitations that came with the usage of her AI. Therefore, she had no way of controlling how the KF decided to deploy and use her AI program.
Could the limitation she referred to be an admission of a low standard or not up to standard software she was handing over? Could that be interpreted as an admission to the fact that she was handing over a software that was not up to standard and that was risky to
much obliged, Your Excellency. Much obliged, Your Excellency.
Sorry, additionally, if I could just add on to that. Additionally, could it not be reasonably inferred by Ms. Lushomo that, given the context, what Kedibonye armed forces are going to use this software for?
Much obliged, Your Excellency. On to the first question that I was asked by your honorable judge, it is a submission that Mrs. Lushomo Ngala had actually improved the status of Bad Target AI, because initially we see that Bad Target was being used in airports to look for suspects who are people who are suspected to carry out criminal offenses. But Mrs. Lushomo Ngala improved her AI program in such a manner that it could be able to distinguish civilian to military personnel. To the second question, Your Excellency, it is our submission, therefore, that Mrs. Lushomo Ngala wasn't supposed to be held responsible for these crimes due to the fact that she had taken every precautionary measure to ensure that the Kedibonye government was aware of the limitations, and before she handed it over, she had made sure that these people were aware that this Bad Target AI was not fully operational, but it had limitations. Therefore, KF government choosing to deploy the Bad Target AI as they did was a choice made by KF and not by our defendant, Mrs. Lushomo Ngala.
Counsel, your time is up, but I have one question for you, and I will allow you to answer it within 1 minute. Can you address the court regarding direct participation? Your co-counsel mentioned that you will address us on this issue. To what extent do you think the civilians in that particular incident were directly participating in hostilities that will deprive them of the protection of IHL?
Much obliged, Your Excellency. I'd first like to give, as I had stated earlier, in the case of Prosecutor Vigalic in the ICTY trial chamber, it had explained that direct part in the hostilities as acts of war, which by their nature or material or opposing forces, which one's forces are engaged with. I'd also like to give mention to the provisions of the commentaries of the ICRC on the interpretive guidance of direct participation in hostilities. Under that commentary, they mentioned that persons participate direct in hostilities when they carry out acts which aim to support one party to the conflict. To this extent, Your Excellency, we see under Articles 17 and 18 that the people in the region of Uzuri had allowed these ULF fighters to be part of their community. These people, furthermore, had gone to an extent of obeying the ULF fighters, of putting up demonstrations in order to prevent the KAF soldiers from carrying out their military operations. And as such, they took part in direct hostilities. Furthermore, we also see them throwing stones towards the KAF soldiers, which led to the injuring of an important sergeant who was part of the KAF, that person had to go to the extent of seeking medical attention, Your Excellency.
All right, thank you, thank you.
I'd like to request 30 seconds, Your Excellency, to make my prayers before this honorable court.
All right, proceed.
Much obliged, Your Excellency. In line with these arguments, it is our submission and our prayers as the defense that this honorable court finds that the case against Mrs. Lusho Mongala as inadmissible and that there lack substantial grounds to believe that the war crimes pursuant to Article 28B of the Malabo Protocol were indeed committed in Uzuri, and that there lack substantial grounds to believe that Mrs. Lusho Mongala is to be held individually criminally responsible for the war crimes pursuant to Article 46B of the Malabo Protocol and any other orders that this honorable court may deem fit. Without any further questions, I wish to cede the floor.
Thank you, Counsel. I now invite the prosecution for any rebuttal.
Thank you, Mr. President. I'll make the rebuttal for the prosecution. Firstly, Your Honors, we would like to tackle the argument of the defense that this case is not admissible, premised on the fact that the quantitative threshold of gravity, as well as the degree of participation of Ms. Lusho Mongala, is limited. Your Honor, on the quantitative threshold of gravity, as we have stated earlier in our submission, and as the ICC held in the prosecutor versus Abu Garda, the death of 12 civilians and injury to 8 satisfied the quantitative threshold of gravity in that case. Herein, it was clearly disclosed at paragraph 21 that 37 civilians died and 41 were injured. Hence, the quantitative threshold of gravity is satisfied. Your Honor, turning to the degree of participation, the defense submitted that the defendant is not she is not superior in the hierarchy of command. Your Honors, the ICC has held in the situation in Democratic Republic of DR Congo that the argument that the defendant does not occupy superior position is not viable under international humanitarian law to hold anybody responsible for a crime. Hence, we submit that that argument of defense is not cogent, and this court should not consider it in the assessment of gravity. Turning to the loss of protected status argued by defense, the defense earlier submitted that the 250 civilians partook in hostilities. However, Your Honor, this is not the case. In line with paragraph 15 of the statement of agreed fact, it was disclosed that the 250 civilians only threw stones at the Kendiboye armed forces after the gunner attacked them. Your Honors, the act of the civilians was just a self-defense, and the ICRC commentary on direct participation in hostilities has stated clearly that act of self-defense does not vitiate the protected status of the civilians. Hence, we submit that these civilians had their protected status intact and they never lost it at any point. Turning to the individual criminal responsibility of Ms. Lusho Mongala, Your Honors, the defense submitted that she is not individually responsible. However, Your Honors, the prosecution had earlier exposed in their argument that she had the mens rea of all the charges charged in the circumstance of this case. And furthermore, Your Honors, in line with the 11 principles adopted to the Convention on Conventional Weapons, they retained human responsibility for any activities taken by autonomous weapons. Your Honors, in the circumstance of this case, Ms. Lushomo Ngala is the one responsible for all the acts of the autonomous weapon deployed in the warfare between Uzuri and Ken Boye government. Your Honors, on this note, the prosecution submits that the case against Ms. Lushomo Ngala is admissible before this court. The war crimes of unlawful confinement, attack against plant protected persons, and attack against protected property were committed in Missouri, and it is Ms. Lushomo Ngala who is individually responsible for the occurrence of all those war crimes. That will be the rebuttal for the prosecution.
Thank you. I now invite the defense for any rebuttal.
Most obliged, Your Excellencies. Your Excellencies, the defense have stated that the number of civilians that were killed was still many. However, the defense did not challenge the quantitative aspect, but it challenged the qualitative aspect in line with the Abu Ghada case. Number two, we still hold our ground that they submitted that Ms. Lushomo Ngala is a superior. However, we submit that as she was not a military leader, she's not a political leader, and during the time of the occurrence of these events, she did not have control over this AI. We submit that the superior subordinate relationship, which is a requirement and seen in the case of prosecutor versus Enver and Amir Kabura, and in the Delali case trial chamber, where we submit that should this court finds that the superior subordinate relationship does not exist, and therefore she should be acquitted. Number three, the prosecution have stated that the protesters only threw stones after the gunners targeted them. However, this is factually untrue from paragraph 17 of the fact pattern, where the gunners were not directed at them, but they were directed to a ULF fighter. Therefore, it is factually untrue that the gunners were targeted at civilians. Number four, we submit that Ms. Lushomo Ngala, having not met the criteria of a superior under the cases as stated above, she bears no individual criminal responsibility. And as the events that led to the loss of these lives were not targeted in any way towards civilians, we submit that the requisite mens rea is lacking, and the prosecution have failed to prove that the mens rea aspect of Ms. Lushomo Ngala or the KAF to commit the alleged war crimes existed. The defense rests.
Thank you. The bench will now adjourn to deliberate, and you will be informed when it is ready to give you the verdict.
The court is now adjourned. Participants and spectators will wait in the courtroom as the judges call to deliberate.
Inshallah.
I think we are waiting for Dr. Fuluke. Okay, I think we have all the judges around. So before I hand over back to the president of the court, could the participants, team 66 and team 84, have your cameras on? Team 66. I think the other team is not here. The prosecution team is not in. Okay, they're here. Okay, Mr. President, over to you.
Thank you very much, everyone. Welcome back to the verdict. Before we issue the verdict, we have some feedbacks to provide to the participants. Each one of the judges will speak briefly to the participants, and I will begin by first inviting Sandra to give her feedback to the participants. Thank you.
Hello, everyone. First of all, congratulations on making it this far. I had the privilege of judging last year's preliminary rounds, and I have to say, and I think one of the other judges will agree with me that the quality of this year has definitely been an improvement as compared to last year. And I think that's great, both on the part of the organizers and on the part of the participants. So I know this might not be your last moot, so I hope as participants, you continue growing the quality of your oral presentations and also of your memorials. And this is good work as a preliminary. But in terms of just comments, and these are applicable to both teams, you should restrict yourself to the statement of facts. I know there's a tendency to want to get creative and to get facts that will suit your arguments, but there's a reason why there's only that which is disclosed in the statement of facts. So please restrict yourself to those. Another comment is to respect time. We know that unfortunately things might not go as planned. Judges will come up with one question after another, and that all eats into your time. However, when you note that you have maybe 2 minutes left and you have 4 points to make, pick out the most important points and make it. You running out of time or you having limited time is not a challenge to speak faster, because then the judges don't understand what you're saying, but rather pick out the most salient points you want to make and put those across. Additionally, you could also ask for time. Ask for more time, perhaps a minute or an additional 2 minutes to make your point. But preferably ask for time before you're told your time is up, right? And another thing is, if you notice that there are certain points that the judges were hammering across both sides. And these are to do with applicability of human rights in terms of armed conflict, and perhaps also civilians' indirect participation in hostilities. I leave the nitty-gritties to the professors on the panel, but sometimes the judges are asking questions to redirect you, We feel like you steered off in terms of law, or maybe even fact, but we're asking you questions to redirect you back. So it's not that we hate you, and we hope that you're able to pick out that, if I said this and they're still hammering this point, maybe they're trying to show me that I made a mistake or I'm contradicting myself, and they're trying to direct me back to the proper law, for example. I think also another thing that all teams need to consider is that as much as you're making your presentations, as much as you're conveying the law, you also need to work on your trial advocacy skills, your persuasion skills, your ability to pivot from one point to the other, your ability to come back to your substantive points when you have been derailed by questions. So there's the law aspect, which you need to be clear on. And in this instance, I know the focus is on international criminal law as well as international humanitarian law, but these are facets of international law. So also certain questions will come to the participants, will be asked to the participants, which might not directly be international criminal law or international humanitarian law, but are part of the broader international law framework. So whereas this moot was a chance to learn and freshen up on your international criminal law skills, as well as your international humanitarian law skills, do also be aware of the broader aspects of international law which could be applicable in this instance and in other moot questions going forward. So I think that's it for me, but also to showcase the good that has been, I have come across in this round. I think all speakers, both teams, they had good opening statements. You had good roadmaps in terms of the issues you wanted to canvass. I saw that you also used extensively case law as well as other materials to support your arguments. So I think there was very good effort on both sides, and I wish you all the best in this round and going forward, of course.
Thank you very much. And I invite Dr. Manuel to give his feedback.
Thank you, Mr. President, for inviting me. So thank you, people. You did a great job. And as the president said in his initial statement to this final, international humanitarian law is really important because it's about people and what's happening on the ground. Yeah, I know people who are targeting IHL more from an academic play perspective, but it's actually what happens to people on the ground in times of war. Yeah, and this is so important, and so happy that you took the time and took the effort to be part of this important moot court. To my points, to the critique, I will. So Sandra said already many things, and I would like to jump a little bit on that and give it here or there a little bit more nuance from my perspective. The first thing is the time issue. Like, be aware that it is not important to finish your argument in the moot court. It is if it's optimal, you will finish. But if you get tons and tons of questions, just accept them. Yeah, it's good if you finish, but this is about, let's say, a learned dialogue. It is not so much to finish your argument, it's about that you can engage with the judges or the arbitrators or whatever kind of moot court it is. And this goes for all moot courts, not only for this one, yeah, that you are in this learned dialogue, that lawyers as equals meet and discussing things. I hope you get my point. And this is not only for humanitarian law or human rights law. This goes to media law or private contract law or whatever. Yeah, in every moot court situation that you find in, take this into your heart and into your knowledge. This is important. Yeah. The second thing is about that law does. So Sandra also said this. So the law does not operate in soul spheres. It operates in interconnected, intertwined. Yeah. And so and this also does not only go for an IHL moot court, but it goes to all moot courts. Like, be aware that there are a lot of different principles that you need to be fit on at your presentation when it comes to presenting. We ask some questions that were not in the sphere of international humanitarian law per se, but they had this interplay about the statehood issue and the territorial issue, for instance. And this is also something that goes for all law, that you have to be sharp on the interconnecting points. And the last thing I want to say is that I'm very happy to see, especially the lady counsels here, to be that good presenters of their cases. So this made me very happy when we talk about gender equality and everything. That made me very, very happy to see this. Yeah, that the women are not shy to take, and let's say like aggressive stance for their respective cause. So thank you everyone for taking the time and effort, and it was a great pleasure to judging this final. Thank you.
Thank you very much. I now invite Dr. Dario to give our feedback.
Thank you very much, Mr. President, and thank you for your presentations. And I would like to congratulate you for this successful final round. You have all put in your efforts, and it's clear that you really put your heart to it. But as always, the largest room on earth is the room of improvements, and this is a platform, is an opportunity to learn and an opportunity to equip yourself and improve in the future. And well done, you're all winners for making it to the final rounds, and well done for the effort you've put into preparing your presentations. And in due course, you will eventually find out who the winner of the round is. But in addition to what the other judges have said, I just want to add that it is important, just to reiterate what has been said, it's important to engage with the judges, especially what the last speaker just said, Mr. Manuel, that it's important for you to engage with the judges. When the questions are thrown at you, don't shy away from those questions, because it's an opportunity for you to demonstrate your knowledge, which you're being assessed on. And that is really important, because sometimes these questions are like cues, trying to avert your mind to an important aspect of the argument you're trying to make, or the judges are sometimes trying to point you in the right direction so that you can make this point and maybe move on to the next point. But just maybe not using that opportunity to shine, to display your knowledge, to demonstrate your in-depth knowledge on the subject is not a good strategy. So moving forward, please pay close attention to that. And also, it's important, as the last judge just said, to avert your mind to the general principles of international law, because everything is interconnected. It's important to equip yourself with these basic knowledge. So, and these issues are, especially the issues that are the principles that are relevant to the facts in issue which you're making submissions about, so that when the questions get thrown at you, because these questions, you're not able to know what the judges are going to ask, but you being equipped with knowledge about the principles of international law that surround the subject you're making submissions about will help you to demonstrate to the judges that you're knowledgeable and you're aware of what the law is, international law provisions, the sources of international law you're referring to, the cases you're referring to, as you brilliantly did refer to cases, and also international, like treaties and provisions of specific sections or specific articles of these treaties that you refer to in the course of your submissions. These are really good things you did. I don't want to hammer on the negatives alone. I would love to also highlight on the positives as well. And well done for your presentations. And I wish you all the best. And in very short future, you will find out what the final outcome is. But congratulations to you all. Thank you.
Thank you very much. I now invite Judge Sebastian to give his own verdict and feedback.
Yes, thank you. So, oh, you want me to give the verdict and the winner is? No.
Feedback, feedback, sorry.
No. Thank you very much, Mr. President. So I agree and fully endorse every single comment that was made by my colleagues. So I will not repeat them, but it doesn't mean I don't think that every single thing my esteemed colleagues said is not important. I think that every single thing is not only useful for the purpose of moot courts, but also for your future as lawyers. For instance, I have been in your shoes in 2006. I've done a moot court. We won, my team won the first international position back then. And every trick, all the knowledge I've picked up then, the manners, the deference, the everything, I still use it nowadays when I'm in court. I'm a prosecutor and prof, but of course I do not use it when I teach, but I do use it still when I'm in courts every day. So it's a knowledge that doesn't go away. So it was absolutely, of course, it was not a waste of time to do as a student, but it was also absolutely not a waste of time to do for your future in the practice, or even if you become professors or else. Because my esteemed colleagues said everything I wanted to say very nicely and way more beautifully than I would, that leaves me some room to make personal comments and positive comments. So thank you very much to my esteemed colleagues. So I will not be critical, but again, I say it on a funny note, but I agree with what they said. So it's not to diminish what they said, quite the opposite. On a personal note, I woke up this morning at 3 a.m. for this moot court. I went to bed at 11 p.m. last night because I had something with work and so on. So when I woke up this morning, I was, oh my God, it's like, really, how I accepted to do it. And, oh, well, I'm not disappointed, and I would do it again because that was quite an exciting. I was on the edge of my seat in every single minute. All of you, and that was a tough decision. Of course, I'm not going to tell you the verdict. That belongs to Mr. President's prerogative. But I was on the edge on my seat for okay, what? Oh, the applicant is so good. What the defendant's going? Oh, the defendant's so good. Like and so on. The argument. Oh, there's this, there's that. So of course there are flaws. There are things you need to improve. Echoing a few of the comments made by my esteemed colleagues, but generally speaking, you were all, and I know my esteemed colleagues all join me. Actually, Sandra made a comment that echoes it, said in different words, more beautiful words, but you've done a wonderful job. Please keep in mind, maybe you discovered doing this moot court, discovered international law, maybe it was your first time dealing with a case like this, and maybe you discovered a passion. But what also comes across is all of you worked very hard. All of you learned very hard. And as judges, we also learn, because this is the beauty of it. So I'm telling you, on a personal note, waking up at 3 a.m., I'm telling you, I would do it again tomorrow, in 2 weeks, just because of the quality, as pointed out by Sandra in her initial comments, the quality of this year's submissions, of the dedication. I know this is stressful. I told you I was in your shoes in 2006. I know you were maneuvering, making the arguments so beautifully, so nicely, in spite of the flaws, in spite of the mistakes. You've done an amazing, outstanding job, and you should all of you should be very, very proud of you. So congratulations to all. Thank you very much.
Thank you very much. So now coming back to the participants, ladies and gentlemen, esteemed judges, honorable participants, and distinguished guests. Good afternoon once again. As we stand at the conclusion of this competition, we find ourselves steeped in this stimulating energy of academic discourse, intellectual challenge, and the pursuit of justice, of course. The past few days have been an exhilarating spectacle of legal acumen, I will say, and very competitive spirit, reminding us of the significance of international humanitarian law in today's complex world. I am humbled, really, to be appearing before this an illustrious gathering, I will define it, filled with young minds, brimming with passion for law and justice. Each one of you has demonstrated, a level of just understanding and knowledge of international humanitarian law, as others have said before me, that not only confirms your commitment to this noble field, but it also, in my view, fosters a sense of optimism for the future. To see these young minds, making these powerful arguments, in a situation that is not very certain. I want to commend every participant for their exceptional performances, your dedication, your meticulous research, your persuasive arguments, and above all, the clarity with which you approach some of the most intricate, and contentious issues of international law generally, and humanitarian law in particular. These were nothing short of awe-inspiring, I will say. The agility in your arguments and your ability to anticipate counter-argument, as I have noted in your presentation, showed your dexterity in logical thinking and your mastery also of the subjects. You have all proven that international humanitarian law is, more than a mere academic subject. It is a real tool that can be wielded in the pursuit of justice. And I believe you have all demonstrated its strength admirably. Now, I'm coming to the much awaited announcement. I reserve my feedback because almost everything that is supposed to be communicated to you have also been communicated to you, so I am not going to add much to that. So coming to the much anticipated announcement, it has been a very tight contest, like has been communicated before. All of you have been formidable opponents. But as we know, there can only be one winner in this competition. So by a razor-thin margin, decided by a vote of 3-2, the case has been awarded to the defense team. This victory stands as a testament to your ability to dissect complex legal issues, craft compelling arguments, and advocate with conviction and eloquence. Congratulations to the winning team, who have been nothing short of exceptional throughout this competition. However, it is crucial to remember that while we have winners and losers in every competition, this platform is about so much more than just winning, I will say. It is about learning, it is about understanding, it is about growth, and most importantly, the relentless pursuit of justice, and the upholding of humanitarian principles. For those who did not make it to the very top this time, let not this be a deterrent. Let it be a stepping stone, towards even greater things. You have all shown great potentials, as we have communicated to you, and there's really no telling what you can achieve in the future with the skills and experience you have gained from this competition. So in closing, I want to express my gratitude to everyone who has contributed to the success of this event, to the esteemed judges, my colleagues who have done a tremendous job in making the tough decisions It wasn't easy. And to dedicated organizers and volunteers, your hard work has really paid off splendidly, I will say. To the participant, I say once again, bravo. You have all demonstrated wit. You have demonstrated knowledge and poise. And you should be very proud of your achievements. Remember, every end has a new beginning. Keep learning, keep arguing, and keep fighting for justice. The world needs more of you. Thank you very much and have a good afternoon.
Thank you very much, Professor Kasim Balarabe, to the distinguished judges. Thank you, really appreciate your time and your commitment in terms of the impact that you put on this young generation of international humanitarian law experts. For the participants, we appreciate your time, and just to reiterate what the president has said, and I've said this before, this is more of a winning and learning situation, not a winning and losing situation. So you need to take that mantle. As I said, the facts of this moot is current an issue that is on discussion in terms of regulation of lethal autonomous weapons at the United Nations and other stakeholders. So it's something that you are able to contribute towards too, in terms of making sure that we are able to have regulations and conventions in regards to this area. So my appreciations to everyone who has been involved. I can happily say I have also learned. I might have authored the problem, but I also learned from the arguments of the participants, and I really appreciate, and my knowledge has increased from the knowledge that I acquired from Professor Kasim Balarabe, who was my IHL lecturer. So thank you so much. I will now hand over to the FIS president to give a word of thanks. Mr. Bukarim, over to you.
Thank you so much, Mr. Swale. To the bench, let me start with the president of the court, Professor Kasim Balarabe. Thank you so much for your time, for your commitment. I know it has not been easy bringing you into this competition, but we thank you so much for accepting the invitation. We thank you so much for providing leadership. We thank you so much for the word of wisdom and encouragement that you've given to all the participants. Similarly, I want to thank Professor Sebastian. Professor has been with us since last year when we started this IHL Moot. He was the presiding judge last year. Thank you so much, Prof. I know the time difference in Canada, as at the time he joined, it was 3:30 a.m. And so thank you so much, Prof, for your time and for your commitment. To appreciate that. To Professor Manuel Brunner, thank you so much from Germany. Also the time difference is also something that we should also need to take into consideration subsequently. But we thank you, sir, for your time, for your word of encouragement, for some of the technical and complex questions you've given to the participants just to bring out the best in them. We appreciate that. Thank you so much. To Miss Sandra. Miss Sandra also was with us last year at the preliminary round, and now she is also here with us. She's joining all the way from Switzerland in Geneva, and we know the time difference also affects. So thank you so much for your time. It's a lot of, she has a lot of research, assignment, everything to submit, but we try to push her here. Thank you so much for your time. And to our own Director of Finance, Dr. Foluke Meridare, also the time difference, she's also joining from Australia. And the time difference there is also not favorable compared to those who are joining from Africa. Ma'am, thank you so much for your time and for your commitment. To the participants, you've heard from our judges. One thing that we're happy with as organizers is the vote of confidence given to us by the judges regarding the quality of the moot and the standard of the participants that made it to the finals. We cannot take the advantages alone, but the previous judges from the preliminary round, they did the job, by each round, they're giving us the best until we get to this final stage. So I want to appreciate all the judges from the preliminary rounds to this period. We appreciate you, to the board of directors of FIS, starting from Director Logistics and Operation, Mr. Swale, who is the author of the moot, and who is also been in charge of the organization, sending emails at a point. The man wanted to break down, and I told him, let's just take it slowly. So for the last 2 weeks, it has not been easy as organizers, but we thank God that eventually we had this final. So thank you to Regional Coordinator for Tanzania, Rwanda, and Kenya, Mr. Patrick. We thank you for your time. These are judges that ensure that we have this finals. So thank you so much to all the country coordinators that we have: Zambia, Uganda, Ethiopia, Kenya, Tanzania, Rwanda, all of them, Nigeria, all of them. I've seen them on this platform, and our director for admin from Abuja, Nigeria. We thank all of you so much. So in the interest of time, the award ceremony is going to kickstart immediately. But for the judges who have been with us for the last 2-3 hours, we can excuse you so that you can also go back and do like Professor Sylvester need to go and sleep. So some other judges need to attend to other people. So I just want to thank you genuinely for your time, for your commitment. We appreciate that. And we hope that next year when we invite you, you also, honor our invitation. Thank you so much. Over to you, Mr. Swale.
Thank you very much. So at this juncture, we'll be going into the awarding ceremony. And as far as the awarding ceremony is concerned, we have a number of awards. I'm sure at the end, you will be able to find out in terms of what exactly the awards are from the president of FIS. For my position is just to be able to declare each of the awards. So we have, of course, the award of the best memorial, both for prosecution and for the defense. We also have award for the best oralist. We have the runners-up award, and then we have, of course, the winner of the watch. But apart from that, there is also other special awards that are going to be indicated by the president. So starting off with the memorials. So the best prosecution memorials goes to Addis Ababa University from Ethiopia. Congratulations to Addis Ababa University from Ethiopia for the best memorial for prosecution. Is there anyone from Addis Ababa here? Okay, I saw them. I think they must have disconnected. Okay, then the best defense memorial. The best defense memorial. This award goes to the University of Nairobi from Kenya. The University of Nairobi from Kenya. Well, the University of Nairobi were unable actually to participate in the oral rounds because they were exams scheduled at the same time. So unfortunately, there was a conflict last minute. So they were not able, but they were able to win the best memorial for the defense. Okay, then moving on to the best oralist. Now, the best oralist has been, as far as accumulation of points from all the oralists of the competition. And after adding all the points, the best oralist of the competition is Jamiu Olatunji Yusuf from Ahmadu Bello University, Nigeria. Mr. Yusuf, I believe you are here. Mr. Yusuf?
Yeah, I'm with you, sir. Thank you.
So, Mr. Yusuf, you are the best oralist for the 2023 FIS IHL Moot competition. Then the runners-up of the competition is Ahmadu Bello University from Nigeria. Ahmadu Bello University from Nigeria. Congratulations to Ahmadu Bello University from Nigeria. Are they here? Of course they are here.
Yeah, we are here, sir.
Okay, congratulations. And then the 2023 FIS IHL Moot Court competition, the winner is Mount Kenya University Parklands from Kenya. Mount Kenya University Parklands from Kenya. Congratulations to Mount Kenya University, the winners of the 2023 FIS International Humanitarian Law Moot Court competitions. I'll now hand over to Mr. President, who will then indicate, of course, the awards for each of the winners in these specific categories. Mr. President, over to you.
Yeah, thank you so much, Mr. Vice President and Director of Logistics and Operation. As organizers, it was our initial plan that the preliminaries will be virtual, and from semi-finals to the final will move the participants to the headquarters of the African Union in Addis. But due to some technical arrangements, that could not happen. So we hope that going forward, this competition will not only be virtual, but at least the semi-final and the final, we should get to meet the participant, depending on the country that have decided to work with us. Having said that, for the winner of this year Moot competition, that is the second edition of the FIS IHL Moot competition 2023, Mount Kenya University. Okay, before I go there, let me start from the preliminary. We have one of our supporters, European Capital Democracy, which is based in Austria. They have given us awards for all the participants. For all the participating universities, you are going to get, I'm not going to disclose the nature of the awards, but it's from the European Capital of Democracy, which has decided to give FIS awards for all the participants. So we thank them so much. So all the participating universities will find a way to get these awards to you. Now, in addition to that, for the winner of this year competition, there is a trophy for the winner. We have our regional coordinator for Tanzania, Kenya, and Rwanda. And our Vice President, Mr. Swale, will be leaving Saudi Arabia to Kenya. So we'll see how that trophy will get to you in addition to the other awards. Similarly, the organization, we put the two of you into a 3-month internship. It's going to be a virtual internship, and it's going to be very extensive, and you're going to learn a lot. So in that 3 months, the two of you will be accommodated. And in the last month, there is a project that you are going to work on. And that project will partner with other institutions across Africa. Don't worry, we have the likes of Professor Sebastian around. So I will not disclose the details of the internship, but you have a 3-month internship with FIS. In addition to that, one of our thematic area is creating employment and skills acquisition. So we're going to enroll you in executive business management training for 1 week. And that business management training is to give you understanding of how the real world works. One thing is to have certificate.
Sorry, you're muted. Okay.
Yeah, it's okay. So one thing is to have certificates. Another thing is to have skills that you can use to bring you money. In Africa today, most graduates cannot translate their knowledge to money making. And so if you graduate and you are not useful, then you become a liability to the society. So that's 1 week executive management training. Each training costs around $200 per person. And so two of you will be enrolled in that training so that in addition to your academic knowledge, you also have a business knowledge so that as a student, if you want to invest, if you want to delve into business, you can do that while you're still a student to take away the financial burden or load from your family. So these are some of the awards that will be given to the winner of this round. Then the runners-up, which is Ahmadu Bello University, Zaria, they also have their trophy as the runners-up. They will have their own trophy. Okay, there is a message pumping up.
Well, the message is from Professor Kasim, the president of the court.
Okay, so the president of the court has also volunteered to give a trophy to Ahmadu Bello University, the runners-up. Thank you so much, Prof. We appreciate you. For those who do not know from the introduction, Professor Kasim is also alumni of Ahmadu Bello University, Zaria. He was the principal partner for, what is the name of this chamber?
Aluko.
No. There is a particular law firm, attorneys. So Professor Kasim was the principal partner for attorneys. Some of us were his junior for like 3-4 years when he was about to leave the university, and those are the people who brought us into mooting. So when he was about to leave the university, Ahmadu Bello University, that was when I joined, and I was the Chief Justice, the Ahmadu Bello University Chief Justice of the Student Union Court, and so both of us are alumni. So for Ahmadu Bello University, that trophy, you'll get it, and then you're also going to get the 1 week business management training, worth $400 for both of you, so that we have the 4 of you enrolled in that business management training, which is just for 1 week. That 1 week is every day, 1 hour per day. So you need to attend the training. After the training, then you write the exam, and once you pass, you get your certificate. So that is the awards for the second runner-up. But for all the participants, like I said, we have awards from, okay. The regional coordinator for Tanzania, Kenya, Rwanda has also said there's going to be a dinner for the winning team, because that is its region. So teams from Mount Kenya will link you up. But generally speaking,
I hope I'm going to be invited too.
So all the team will benefit something in terms of awards. All the participants will be given an award, and then we'll find a way. The challenge is sending it across, but we've decided that we'll send it to East Africa, and then from East Africa it can move down to West Africa, and another participant will get it. So that's not a problem. But at the end of everything, as an organizers, like we've been saying, it's not about mooting alone. It's about learning. It's about bringing up African scholars. It's about bringing up people who understand the system. It's about networking. Now you have the likes of Professor Kasim, you have the likes of Professor Sebastian, you have the likes of Professor Bruna, you have the likes of Dr. Mary, Miss Sandra. These are individuals that ordinarily you may not come across them ordinarily, but for a platform like this. So network with your fellow participants from Africans, network with most of these judges. They've seen you, they've heard from you. If you want to do your postgraduate, for instance, if you find yourself in Canada, you can just reach out to Professor Sebastian. You find yourself in India, you reach out to Professor Kasim. You find yourself in Australia, you reach out to Dr. Mary. You find yourself in Germany, you reach out to Professor Bruna. You find yourself even in Saudi Arabia, Mr. Swale is there for you. You find yourself in Switzerland, you reach out to Ms. Sandra. So this is a platform for you to network, to meet people that ordinarily you would not have met them. So we want you to explore that possibility. We want you to to say that your life is better. After this moot competition, you become better individual. So that is the essence of this entire moot competition. And I want to state again that this journey started a long time ago. It's just that for the last 2 weeks, we'll be having the moots. But the preparation started a long time ago, like 4 months ago, trying to, bring on board the judges, the participants, every other person. So thank you so much.
Mr. President?
Yes, sir.
Sorry, before you end, I've just been informed that the Dean Faculty of Law at Ahmadu Bello University, Professor Salim Bashir, is also with us here.
Okay. Okay. Before I round up, let me give Professor Salim an opportunity. But before then, let me introduce Dr. Salim. We went to the same Nigerian Law School Lagos campus. We were together at the Nigerian Law School Lagos campus. That is the Dean Faculty of Law, Ahmadu Bello University, Zaria. And then we also met at the University of Pretoria. We attended the same Right to Development in African course for 1 week at the University of Pretoria. And when he was doing his PhD at the University of Stellenbosch, I was invited by the, I think, African Institute for Religious Dialogue or something to present a paper on religion and corruption. So I went to University of Stellenbosch, I met him, he hosted me. And since then, we've become friends. So let me invite the Dean Faculty of Law, Ahmadu Bello University, to say a few words, and then we wrap up this discussion.
I think he has just been disconnected. I'm not sure whether it's a technical issue. Mr. Jafar, could you confirm?
Okay, while we're waiting for the Dean, this is just a recap. In the last 2 weeks, we've had series of preliminary rounds in between Professor Sebastian and other judges, the president of the court. We had a peace summit. And this peace summit, African Peace Summit, we had presentations from different presenters. And among them is the renowned Pan-Africanist, that is Professor Lumumba. Professor Lumumba was part of the invited guest. We also had the Senior Advocate of Nigeria in person of Professor Amdaka Nike, who was the Dean Faculty of Law, Kwara State University. We had Mrs. Monica Mwanza, who was the Deputy Chief State Advocate in charge of taxation and financial crimes in Lusaka, Zambia. We also had presentation from Mrs. Stephanie, who was a lawyer by training and a legal officer with the Economic and Financial Crimes Commission in Nigeria. We had also presentation from Mr. Ogwal. Mr. Ogwal is a London associate and retired judge advocate with Uganda People's Defense Force in Uganda. And then our chief guest, Mr. Mustafa from Sierra Leone. So all these people made presentation during the Youth Peace Summit, and we have recommendations that we might share with our judges so that you can have a holistic idea of what transpired. And so after the preliminary and the Peace Summit, we had the quarterfinal, the round of 16, and then the round of 8 semifinals, the round of quarterfinals, the round of 4 semifinals, and then today, which is the last day. And all this will not be possible for the teamwork of FIS members, starting from the board of directors, from Mr. Swale, Dr. Mary, Mr. Akinwumi, Mr. Patrick, Mr. Enoch. Mr. Patrick is the regional coordinator, Tanzania, Rwanda, Kenya. Mr. Enoch is the Ethiopian coordinator. Ms. Marvelous is Zambia. Mr. Daniel is South Sudan. Mr. Shafi, Nigeria. Those are our branches. Those are places where we have branches as an organization, and we have country coordinators for all these countries. So this competition will not be possible but for their sacrifices And so I want to especially thank all of them, especially Mr. Swale. It has not been easy, combining all this with his assignments. He's just joined them at Prince Sultan in Saudi Arabia, so it has not been easy. So we thank you so much, and all the country coordinators, we thank you so much. Do we have the dean now?
I think he has not joined, but what I would like to also add is that we will share an Excel sheet to all the participants and as well as judges, which will just confirm the spelling of your names for the purpose of issuance of the certificate for participation. And then I think one thing that Mr. President might not have mentioned, there is a number of other issues we are on discussion in terms of partnership as far as the contribution on some of the areas that were covered in this moot. And therefore, since there is discussion ongoing, we might bring on board some of you in terms of being able to also make a contributions towards that to the relevant stakeholders. And therefore, that's all from my side. I wish you the best of luck. Thank you. It has been an honor. And I'm sorry for the too many emails that I sent to each of you, but yeah, I was trying to do my job. Thank you.
All right. If there is any other comments before we close the edition of 2023, if there is any short comments, maybe from the participants or the judges, once again, we can give one minute, and then we close the 2023. I will invite, I think
Professor Sebastian wants to say something.
Okay, yes.
Very quickly, no more than 20 seconds. I just want to reiterate congratulations to all participants in the final round. It was, again, quite impressive. It was quite exciting. It was every judge was on the edge of their seat. So congratulations to all of you. And it was an honor and privilege. And I raise my hat to Swale as well, if I may. He worked very hard to make it. And of course, Abdul Karim as well. So I'm not saying only Swale, but I know Swale because we had several exchange of emails and so on. So I know he did everything possible to make this year's edition a huge success, which it was, to say the very least. So thank you, everyone, and I wish you all the best. Thank you.
Thank you, Prof. If we have any other comments.
We didn't get the reaction from the winning team.
Okay. Mount Kenya, do you have anything to say?
I'd like to take this opportunity to thank each and every person who made this opportunity available for us. And we are happy that we've won this round, but we also want to extend our congratulations to the prosecution team. They were really good. And thank you so much for this opportunity.
All right. Thank you so much. Yes.
Yeah, I'll say I'm very happy for this opportunity. I'm very happy that we won. But the prosecution was also a formidable team. They kept me at the edge of my seat. I've learned a lot. I look forward to have long bios like our judges had, 5-minute long bios. So I'll keep on putting the work because I know it takes time and it takes a lot of work. And I wish all of us, as this organization grows, that it will incorporate more people and it will lead to a better Africa for us. Thank you very much.
All right, thank you. If we can also have 30 seconds from the prosecution team. That's Mustafa and Yusuf. Are they still online?
Yes, I'm with you, but my co-counsel is not available at this moment.
It's okay. You can do that on our behalf.
All right. I just want to thank the judges and the organizers of this event. So I've given us a room to enhance our knowledge on international humanitarian law. The experience was really worthwhile. I really appreciate the opportunity. And to the winning team, we look forward to having further engagement with everyone. Thank you so much.
All right. Thank you so much. Okay, I think so. Also to the coaches, thank you so much for your time. So at this point, let me invite Mr. Swale to declare the FIS IHL Moot Competition 2023 officially closed.
Well, I would like to pass that to the Director of Administration. I think he needs to say something. He can't just be here. Mr. Akinwumi John.
Yes, thank you very much. Good afternoon from Nigeria. My name is Akinwumi John Ayobami, and I want to sincerely appreciate everyone that has taken part in this moot. Though I've not been actively available due to my schedule, my boss traveled and I'm doing like 3 persons work in the office. Even right now, so my docket is still very full, preparing for next week. But I sincerely apologize for that. To the judges, I can see Professor Kasim, and then Dr. Foluke, and then at our judge too. I can't see your name, but I can see the email, and then also Sandra too. I really appreciate. I think it's offline. And to the president and other directors, the country coordinators, the participants from Kenya, and then the participants from Nigeria too for the final round. I really appreciate you all. And then on behalf of the Firdaus Integrated Services, I think by the power conferred on me, I hereby declare this Moot 2023 close.